to really welcome the Department of Transport, acting DG and the officials who's here in terms of our colleagues, politicians. Valerie?
Chair, I've seen some of the departmental officials here and the railway safety regulator. But Ms. Mpondo will be able to say who exactly is in their delegation.
Good morning, Chair. Good morning, Valerie and colleagues. I see there's an acting DG who's leading the delegation. And then there's one official, there's the acting DDG, Godfrey Maluleka, who has joined too. And there's one official from PRASA. The rest of officials from PRASA are going to join at 11. And there's a Silo Mukobiani from Department of Transport too. I'm not sure about the delegation of RSR. I will do follow up now. Thank you.
Okay, thanks, Tandy. Thanks. You are heartily welcome, everybody. And welcome also to our presenters who are already with us here today. We are going to have a very long day. I will allow people to talk right at the beginning so that as we move, we move in tandem. There are members who would want to say something. I want to allow them to do exactly that before we get into our work. I see Umhlekazi Ubaba Uhunsinga, his hand is up. That hand will be followed by Honorable McDonald and then Honorable Makosini. You must pardon me, I will be short and to the point today. Honorable Pete May will follow. Those are the four hands I have. Otherwise, if there's anybody who still wants to say something, I must be alerted now or they must keep their peace. Thank you, Mhlekazi.
Chairperson, allow me to also say it's delightful to see you. And I also wish that you had a good constituency period. And it's also great to see all the other colleagues. Chairperson, I see that today's program is set out to lead until 3 o'clock. Unfortunately, I've got a very urgent meeting at 3. And I ask you to please excuse me at 2 o'clock since I need about an hour's driving time to get there. If that would be in order with you, I'll really appreciate that. Thank you, Chair.
Mhlekazi, thank you very much. Happy to see you in good spirit. Thank you very much. Honorable McDonald.
Chairperson, thank you. And once again, officially say good morning to you, Chairperson, and to all the other members. And I'm glad to see that everybody is safe after a long constituency period. And I welcome the presenters that are here and the department. Chairperson, I only want to raise something. And Chairperson, I don't want you to constitute it as a fight or something. I just need a little bit of clarity, Chairperson. Chairperson, did we not agree that the rail safety bill, we are going to do the public hearings physically so that we can engage with the people? Chairperson, I'm not opposed to what we are doing. I'm just following procedure. I think we did discuss this in the committee and we did say that we are going to try and do, and I think the words we're going to try and do this, because the people that use the railway is not people that have Zoom, and it's the poorest of the poor that use the railway. And I think we are slightly disaligning ourselves from the communities that we are serving, Chairperson. And I just wanted to raise that, Chairperson, and I'm terribly sorry that I don't want to put salt in the wound or upset anybody. It's just that I feel that the people that we are supposed to be serving are not the people that will be able to engage in these public hearings. Thank you, Chairperson.
But thank you, Honorable McDonald. Could you open your video so that I can really address that point quickly with you? We are not at that stage yet. Today, we are taking presentation, written submissions, and I've seen that there's somebody who wants to do an oral submission, which is at the beginning phase or stage of this bill. We will get at that point where we then consider getting to the people physically listening to them. That stage is still coming, unless I'm wrong. Valerie?
That's correct, Chair. The practice is that the committee first starts with the submissions that were made in written form, have those hearings, and then on the last day of the hearings, then confirm the decision to do provincial hearings. Then the staff will go ahead to get a costing for the hearings and submit that for political approval to the House Chair. I think members who were here for the 5th Parliament will note that when the committee were doing the provincial hearing for RAPS, we also started with hearings at Parliament that were then followed by the provincial hearings. So as soon as the committee then agrees tomorrow and confirm that there will be provincial hearings, we submit an application for political approval and thereafter start the hearings in the provinces.
Honorable McDonald, are you here?
Yes, I am, Chairperson. I'm covered, Chairperson.
Is that clear?
Yes, it's clear now. Thank you, Chairperson. I understand now. I think we are on the right track now. Thank you, Chairperson. Okay,
let's not rub salt in anybody's wound then. If we are all fine, thank you. Babu, who was next? Babu
Myself, Chairperson. No.
Oh, sorry.
Chairperson, with that explanation, I think I'm also covered because I was going to echo the very same sentiment that was echoed by McDonald. I'm covered. Thank you very much.
Thank you very much. Let's note that the procedure so that we don't spend time repeating the same procedure. We will talk about that matter at that stage and conclude. Take a follow that decision as it is. Babu Keta Mabala, uthini baba nawo bozotsho njani?
Lutho mangethe, sawubona mangethe.
Enjalo.
Greeting to all members and the officials. Honorable Chairperson, I will ask to be excused at 3 o'clock because I have a meeting at 4 o'clock in Johannesburg. And then another thing, the Chairperson, I will ask you to look at it. If they can, the department can make a presentation about this filling of potholes. Thank you very much, Chair.
You left the name of the place where you want the potholes to be sealed, but I think the department is here. We will follow that up. Thank you very much. Please lower your hand. Babu Keta Mabala, thank you. Honorable Pete May.
Thank you, Chairperson. All I want to say, a warm welcome to all of you, and I hope I see you soon in Cape Town. Thank you.
you very much. Thank you very much.
In person.
Thank you. Pleased to see you also. We're done with politicians, I think so, colleagues. Thank you. And that Mwako Makaipeya, I've seen the minister also is here, if I'm correct. Welcome, Jola. Welcome in our midst. Thank you. That Makaipeya.
Thanks very much, Chair, and good morning to the Chair and the honorable members and colleagues on the call. Chair, I just wanted to add that with the introduction that we have made from the Department of Transport, we do in our meeting have our colleagues from the RSR who are the implementing agent. We have Mr. Reginald Njingila from the RSR. We then have Koliswa, and we have the head of legal, Vacha Sulal from RSR. And then we have our advisory team in terms of the drafting. We have Advocate Bernard Grill in the meeting, Chair. To then record, Chair, that I will not be staying for the whole meeting, Chair. I'll request to be excused, but I'll have a capable team in the meeting led by the acting DDG for Rail, Mr. Godfrey Marulek. Thanks very much, Chair.
Dade Makaipeya, we take it that you are acting as an acting DG, and thank you very much for alerting us. We will continue with the team, capable as they are. We are left with a minute to start our presentation. Honorable Minister, say.
Good morning, Chair.
Oh,
The minister is not in the meeting. The minister is in the cabinet committee. So I don't know, you saw Honorable Fikile Kumalo. My apology.
Oh, it's Fikile Kumalo. Okay, thank you very much. Valerie, is that your hand? The portfolio
Yes,
committee.
Chair. Yes, Chair. It is my hand. Just for the record, Chair, Mr. Mangu is on the oversight visit to KZN with the ad hoc committee, and our Parliament legal advisor is in a finance meeting now, but they are aware of the meeting and they have all the documentation, him and the state law advisor. So they'll join when they can, Chair.
Thank you very much. I hope that is not going to lead to hiccups as we move to that stage where we need their input. Valerie, but thank you very much. Any other apology except those, Valerie? Are we good to go?
Chair, we're good to go. I know Ms. Kumalo was going to travel, but she's already in the meeting, so that is fine.
Thank you very much. The time is 9:15, and according to my schedule, we should be getting a submission by Mbombela.
Chair, can I interrupt you?
I want members to raise their hand. I've requested that at the start of the meeting. Mtungwa, let me hear you, but I am going to request that we follow that approach. Mtungwa.
My sincere apology, Chair. Greetings. No, I would just want to clarify my apology. Maybe the content was not clear to Miss Valerie. I said I am joining the meeting now, but I will be disconnecting at 12 because I'm flying. So I will join thereafter when I land Cape Town. That was my apology.
Okay. Okay.
Yes, thank you.
Thank you very much. Honorable Member Fikile. we are allowing a submission by Mbombela Concession Company. Mbombela, according to my knowledge, is up there next to Swaziland in Nelspruit. Can we allow a presentation by Mbombela Concession Company? Are they here?
Yes, Chair. Good morning, Chair.
How are you?
Good, thank you, Chair, and welcome to all of the colleagues. My name is Tawanda Shamu. I'm representing Mbombela Concession Company. So not Mbombela, the province or Nelspruit, but Mbombela, we're a private company on the Gautrain project. So hopefully we're still welcome at this presentation, because I see there's a lot of members of the government sector or the public sector that are in the room. But we're here to make a submission on behalf of the private party on the Gautrain project.
Yeah, no, it's okay. Please be aware that you have time up until 9:50, and please don't go over that, because we have a jam-packed schedule. Otherwise, we are pretty much happy and ready to listen to you. Over to you, sir.
Okay, thank you very much, Chair. Chair, with your permission, may I please put up a presentation that we had prepared?
Valerie, you need our help, sir?
No, I can just share my screen if that's okay with you.
Share your screen, we are all yours.
I will try my best to keep to the allocated time, Chair.
Thank you very much for being considerate, sir. Thank you.
Is it visible?
I can see the Mbombela, when you go Mbombela, the train on the screen.
Thank you very much, Chair. So as I said, I'm Tawanda Shamu. I'm the Contracts and Commercial Executive at Mbombela Concession Company. I'll give you an overview of the actual Gautrain project as part of this presentation. I think it's quite important so that you can get a sense of the context of the submissions that we're making at this point in time. Chair, I've just been informed. Are you still seeing just the cover page?
Do the presentation mode.
Yeah, I'm trying to.
Yeah, no, on the left side, there are slides of presentation. I think you want to zoom into them. We can see them, although they are not in the middle where the cover page is.
Okay, let me try to sort it out. Which one is that? Okay, so there we go. Apologies again, Chair, while we just sort out the technicalities.
And now I will be telling the public that trains are not moving today.
I think it's good. All right, Jason, not to waste any more time. What I'll do is I'll give you a brief overview of the Gautrain project so that you can have some context to the submission that we're going to actually make. But in essence, what we want to do is to make two general categories of comments. and that's related to the holder of the safety permit, and specifically who is obliged to make the application to the RSR in the context of a PPP. I think the challenges that we faced as the concession company on this Gautrain project is that there's a little bit of uncertainty when it comes to the existing legislation with regards to where that obligation actually sits. So you'll see, we think that a change to Section 30, the inclusion of a definition of a safety permit and the insertion of a new definition being a concession network operator is a potential solution to this particular problem. The second set of comments that we want to talk through are really related to the powers of the regulator, the CEO, the board, the inspector to an extent. And ultimately that's to try and get a good balance between the actual objectives of the RSR and balancing that with the interests of the various operators that are currently on the system. And I must stress that although this presentation is being made by us as Bombela on the Gautrain project, we do think that the proposal that we want to put forward is workable for any sort of PPP structure. And I think that's the biggest challenge that we've picked up as a concession company with regards to the current act. So if I can move on to the next slide. This is just an overview of the current Gautrain project. I've indicated the public sector participants in gray blocks, and the private sector participants, I've included them in the blue boxes over there. So the concession agreement that's currently in place is directly between the Gauteng provincial government. You'll see I've put my mouse over them over there. And they've got a concession agreement with Bombela Concession Company, the company that I represent. And that is to design and build and then operate and maintain the Gautrain system. So we completed the construction phase of the Gautrain in June 2012, and we will be operating and maintaining the system until 2026. Whereafter we will transfer the system back to the Gauteng provincial government. As it currently stands, the Gauteng provincial government itself is represented by an entity called the Gautrain Management Agency. I think they're in this meeting and they'll be presenting after us, if I'm not mistaken. But ultimately, their job is to manage the concession agreement between the province and the private sector party. So as I indicated earlier, ultimately our obligation was to design and build and then operate and maintain the system. That we achieved through the appointment of two subcontractors. The one is called the Bombela Turnkey Contractor. And they, as I said, did the design and construction. We're pretty much not part of the project anymore. And then secondly, the Bombela Operating Company. So as it stands, the Bombela Operating Company, through practice and I suppose through agreement and negotiation with the various role players on the project, they're the entity that has the main interface with the RSR, and they are responsible for applying for the safety permit. Now, the reason why I've done this overview is to sort of set the scene for the more detailed submissions that are going to come through in the following slides. And that's because under the provisions of the existing Act, any of these entities, whether it's the province, the GMA, us as Bombela Concession Company or the turnkey contractor or the operating company, could be interpreted as being obliged to make an application for that particular safety permit, which obviously creates uncertainty and potential risk in terms of the project and the general operations themselves. So the committee issued out the first bill, I think it was last year or the year before, There were comments that were issued out by Bombela Concession Company and by the Gauteng Management Agency, which dealt to an extent with this particular issue. And the committee made a few amendments, particularly to the definition of a station operator, an operator, a network operator, and to Section 30 of the Act, which were designed to particularly take care of this, this particular issue. It was a step in the right direction in the sense that it clarified that the public sector is very much not obliged to make an application for a safety permit. However, it still left the private sector entities here unclear about where that actual responsibility sits. So what we proposed is to make changes to the wording that's currently in the bill that effectively will try and simplify the definitions and do as little violence as we can to the existing bill, but still incorporate the PPP structure in the actual act. So the insertion that was made was to include a carve-out in Section 30.1 that refers to any person who wants to undertake any railway or railway operation must apply to the regulator in the prescribed manner for a safety permit. But in the case of a person who is a concessionaire, and this was the inclusion that was made to accommodate our comments, a person who's a concessionaire operates, constructs, maintains, or manages a railway, or conducts or undertakes railway operations on behalf of another person who owns, finances, or controls the relevant assets, that concessionaire or that person who so operates, constructs, maintains, or manages that railway, also who conducts or undertakes such railway operations is, for purposes of this chapter, regarded as being the applicant or safety permit holder, as the case may be. So if I just focus on the words concessionaire, operate, construct, and I go back to the previous slide, you'll see that unfortunately, it could be any of Bombela Concession Company, Bombela Turnkey Contractor, or the Bombela Operating Company that is actually obliged to make the application to the RSR for a safety permit. The issues around the public sector participants, I think, are adequately addressed in that wording. But for the blue entities, I think the problem still exists. So our suggestion is to rather remove the insertion, go back to the original wording in Section 31, but just add the words as defined at the end of the sentence in Section 30.1. And the reason for that is that we can then capture in the definition of a safety permit the different entities that are obliged to then apply for a safety permit from the RSR. And that would be a concession network operator, and then a network operator, train operator, or station operator, or any combination thereof. The new definition that we've put in there is a concession network operator. And this definition specifically then incorporates a reference to PPP, public-private partnership arrangement. And you'll see in the next slide that then talks to the definition in the PFMA. So again, this covers not just Gautrain, but any sort of future PPP projects that are there. And then importantly, it then ring fences a concession network operator just to the person that's responsible for the safety of a network or part thereof, and then authorizing and directing the safe and secure movement of rolling stock. If I go again back to slide 3, that then makes it clear that it is the Bombela Operating Company that would be responsible for obtaining that particular safety permit, which I stress is currently the situation in practice, but there still is a legislative risk on the project that could be challenged. I previously mentioned that the definition of a concession network operator expressly refers to a PPP arrangement. And what we then propose doing is inserting what a PPP arrangement is into section 1, so that it can expressly cross-refer to the PFMA, and that then covers all types of PPP structures. So this structure can then be cut up in any other way that anyone wants to set it up, but the wording that we propose would still be sufficient to protect both the public sector and the concession entities, etc., that are involved in that project. The other benefit of the proposed change that we want to make is that it also then simplifies the definition of an operator, as well as the definition of a station operator. So the wording that's in station operator as amended, as well as in the operator, you'll see is similar, is actually word for word the same as what's set out in section 30.1. So ultimately, if we can remove this wording in section 30.1, cure the conundrum around the PPP structure with an amendment to the safety permit definition, the introduction of a new concept being a concession network operator, we then don't need to make any changes to the definition of operator or to station operator. Linked to this, and again, without doing too much violence to the current wording, is the definition of a network operator. And our suggestion will be to simply remove the word ultimately, because it again causes or potentially causes confusion, or the risk that one could argue that in this sort of PPP type setup, either the concession company or the operating company is ultimately responsible for operation and maintenance. So our recommendation there would be to just delete the word ultimately in section 1. And again, I think that would add a level of certainty when it comes to those particular definitions. We've spoken about the definition of a station operator. And I just wanted to pause here, Chair, and just ask if we should open up the floor for questions or discussion or debate now, because I know it's quite a lot of detail that I've run through fairly quickly.
Thank you, sir. My schedule is as follows. You are given time up until 9:50. I'm sure you are left with about 15 minutes. Finish your presentation. We will then take discussions thereafter.
Okay. That's fine. So that brings us to the end of the first category of changes that we put forward. And that's really to do with the definitions and then incorporating a PPP structure into the RSR Act. The next set of comments that we wanted to table or submissions is in relation to the powers of the regulator and the CEO and the board. And as I said in the introduction, is to sort of find a balance between the regulator achieving the objectives and also balancing the interests of the various train operators. So the first set of comments is related to reasonableness. And we wanted to propose if there could be slight alterations to section 7.1a, 39.3 and 44.3a of the current bill to the insertion of the word reasonable in certain portions of the provision. So specifically in 7.1a, we wanted to insert the word reasonable. And let me read the sentence to say that the regulator must, for purposes of achieving its objects as contemplated in section 6a, perform its functions in a fair, equitable, transparent, efficient, reasonable, that's the proposed insertion, and cost-effective manner. And the reason for that is we think that it just aligns with the general objects and purposes of the Act. And again, I think it gives a level of protection in terms of the actual interests as well of the various operators. Similarly, when it comes to requests for information from the regulator to the operators, our submission is that the timeframes that should be put forward to the operators to provide that information to the regulator should also be subject to a level of reasonableness. In relation to section 44.3a, doesn't use the word reasonable, but it's the same basic underlying principle. And that's to say that when a railway safety inspector wants to exercise his powers to enter and search any premises, they should do so that provided it is safe to do so. So again, just acting in a reasonable manner. The second set of comments that we wanted to table are in relation to a more consultative or collaborative approach between the RSR and the various operators. So the changes here are in 7.1D1 and 31.2, which is on the next slide. And our submission would be that in developing the various guidelines for safe railway and railway operations, that this be done in consultation with the operators. So with the RSR engaging with the operators before actually finalizing or gazetting those particular regulations. In section 31.2, this is in relation to the imposition of special conditions to the safety permit. Our view is that it would be beneficial if the regulator is prior to the imposition of these special conditions, if they could again engage with and consult with the affected network operator. That could also be the word operator, but as long as there's some sort of consultative process that's included in there, we think that that would be beneficial to the actual act. The second last set of comments or submissions that we have really about clarification on some of the wording. So in section 35A1, the RSR sort of is given discretion to issue out a safety permit for anything between 3 to 5 years. It's not clear to us from the proposed wording what the criteria is that the RSR would use to make that particular decision. We take note that there is wording to say taking into account the requirements and interests of railway safety, but that in itself also seems a bit vague to us. So we'd request that the committee sort of look at clarifying or tightening up that wording just to make it more clear. And second set of comments sort of linked to clarification is in relation to the amendment of the conditions in a safety permit. So under 32.1 currently, the regulator may, in justifiable circumstances, amend any condition imposed on a specific safety permit, but it is not clear what justifiable circumstances would be. And the plea from our side would be for the regulator, for the committee to look at more specific wording or set out specific instances when the RSR could amend those conditions that are in a permit. The final set of comments are more general. I think two of them are related to costs, and the one is related to the power of the regulator, CEO, and the board, and how those play out. So section 27B, 32, and 66 refer to the fee that's paid to the regulator, and that it is determined by the minister. But it's not clear at all how that fee is actually calculated or determined, which creates uncertainty for the various operators. And you see that the second comment that we've got in this column is that our request would also be for these increases to be maybe subject to some sort of reasonable cap, just to protect the financial position of the various operators and not expose them to sort of unforeseen price shocks and price increases. We also think in section 34B that to the extent the regulator requests information from an operator and that information is subject to an independent review, that the cost of that review should rightfully sit with the RSR and not with the operators. But currently the wording is unclear about who would actually carry that particular cost. And the last comment that we've got, though it is quite an important one, is in relation to the suspension or revocation of a safety permit. So section 33.2 currently allows the RSR to revoke or suspend a safety permit, but due to the obvious pretty big consequences or adverse consequences that can flow from such an action, our suggestion would be for that power to be exercised by the CEO, but subject to prior board approval. And that's it. I finished with 7 minutes to go, Chair. So hopefully you're satisfied with that performance.
Thank you, sir. You are pretty within your time. Are you sure you are finished?
As far as I can tell, yes, I am.
Come again?
As far as I can tell, yes, I am finished. I think those are the points we wanted to raise, really.
Thank you very much. With your permission and the readiness from your team, we are going to get to discussions now. Thank you very much for the presentation. Thank you. Honorable members, there is the presentation. We have time to discuss from now up until 10:10. If there is any clarity seeking question, just clarity seeking question, we will be able to get into the details in our own time as a portfolio committee. Let me see hands that wants to ask for clarity, seeking questions. Do I see any hand? Honorable Lawrence McDonald, Honorable Ketamabala, those are the two. Honorable Unsinger, those are the three hands in that order, please. Thank you.
Thank you, Chairperson. I'm not going to put my video on, Chairperson, because I'm suffering with some internet issues. But thank you very much, Chairperson. I just wanted to, on the comments that were made, and thank you very much for the presentation, and thank you for ending on time or before time. On 7, let me just get my notes here, Chairperson. The one on reasonable. Now, Chairperson, I'm not 100%. I don't understand, because in law, you never use the word reasonable, because reasonable allows you to take things in consideration that might ordinarily not be within the law. So I think I don't agree on the part of reasonable and reasonability and etc. Then on 40, let me just get to that section, Chairperson, so that I can copy it verbatim. Yeah. On the okay, so on the one there that where they suggest that it's provided it is safe to do so, where 44.3a, a rail safety inspector may, for the purpose of subsection 1 and subject to subsection 2, enter and search any premises. I also don't agree to add provided it's safe to do so, because the whole purpose of this bill is so that they can do go to a premises and take documents or spare parts where there was an accident or they're investigating an accident, Chairperson. So when you provide it safe, then somebody can at the door say it's not safe, they can't go in while people are hiding things, and I don't think that's going to fly. On the one of the fees paid to the regulator as determined by the minister in terms of section 66, I agree that the determination on how the fees are determined and the annual increases, I think the wording needs to be beefed up there. I do agree that, and also the annual increases, because currently we need to, the country is under extreme pressure, and we don't want a situation where the poorest of the poor all of a sudden has a huge fee increase in transport in rail when the fees has maybe gone up 100-fold. So on that one, I agree, Chairperson. And then on the subject of 33.2, subject to subsection 3 and 4, the regulator may revoke or suspend the safety permit if the permit holder fails to comply with the conditions set in terms of this act. I don't agree with them that it must go to the CEO of the board. We can't have a situation where an operator is operating unsafe on the lines, or there's a safety concern, and now you have to wait for the board to sit to make a decision. No, Chairperson, I don't agree with that. But that's my submissions. Thank you, Chairperson.
Thank you, Honorable MacDonald. We are not yet at the stage where we will interact with this presentation, agree or disagree with them. We are at a stage where we want clarity so that as we engage with the presentation as a portfolio committee, we have clarity on all the points that have been raised. I thought I should just raise that point to members that are coming next. Honorable Member.
Thank you, Honorable Chairperson. No, Honorable Chairperson, mine was, thank you. First of all, I want to appreciate the presentation. And the second point is that my point, which was, it's been covered by Honorable MacDonald, which was reasonable. Now, but there is that just clarity seeking information from the presenter. When you see section 27B, 82 and 66, where they say fees to be regulated as determined by the minister, in terms of section 66. So I'm trying to check. There is no suggestion from their perspective about the wording. If they can give us what is their suggesting, because that one is vacant. They never comment on that one. Thank you very much.
Thank you very much, Honorable Sithole. Honorable Chris Hunsinger.
Thank you, Chairperson. Firstly, thank you for what I regard as a very valid and relevant and well-aligned presentation to definitely improve conditions for the future. And thank you for your submissions. Chairperson, I have 4 questions. The first question relates to a remark which our presenter made on expressing the structure between what he had there as a form of a table of private and public sector on the interface then between Bombela and Gautrain provincial government. And in light of the current experience and then the suggested new bill with its content, he made the remark of particular uncertainties and risks. Could you expand on your current experience in this structure and how this new bill would then introduce particular uncertainty and risks? Are there more, or did you cover all of those in the slides that follow? My second question is one where you suggested that the PFMA would adequately cover potential risks in this interface of public and private sector. Do you regard the PFMA in its current form as adequate to deal with all the potential things that can go wrong in this relationship? My third question also deals with your remark about reasonable, and that was on your section 7 sub 1, I think it was slide 10. In your current experience and within the current environment, given conditions and circumstances which you have built up significant experience in, how would you define your suggestion around reasonableness, and how could that be improved in its current form or suggested form? My fourth question would talk to your slide 14, where you dealt with sections 27 sub B and 30 sub 2 and 66, where so the suggestion was made that fees should be determined by the minister. Now, obviously, one would want particular check and balances within that equation. What conditions of check and balance would you suggest should improve this condition, where it was suggested in the original wording that the minister should determine this? What other check and balances might be of consideration? A tribunal to be approached, or a role from Parliament side? What check and balance suggestions would you have? Thank you, Chairperson. Those are my 4 questions.
Vier vrije van de achtbare leden. Dank je, achtbare leden. Chris Hunsener. Let's go back to the presenter and get some responses. Are we still there?
Yes, I'm still here, Chair. Just to put, there was obviously a number of questions that were put forward. Some I think were more about debating the actual content of the presentation. And then some you said were related to more clarification points. So if I understood you correctly, the point of this discussion is not to debate the wording so much as just to let the forum fully understand the content of our submission.
Are you done, sir?
Yes. I just wanted to be given guidance in terms of how to approach the responses.
Oh, okay. Well, I thought that will give you time to explain yourself more in terms of the questions that have been asked.
Yes.
Yes.
Okay. All right. No, I understand. So the first question that was raised was, and forgive me, I couldn't take note of the names of all of the various members that asked questions. But the first question was related to 71A, 44.3A, and reasonableness. I think it was Honorable MacDonald that made the suggestion. So I think, and the word reasonable is always going to be quite a contentious one in any sort of legislation. But our view is it actually helps to give the RSR some level of flexibility in terms of how they actually execute their particular functions, while at the same time giving the operators the protection that they need in terms of the RSR Act and how those particular conditions, etc., are implemented. So while I fully take on board the point raised by Honorable Mr. MacDonald, that reasonable is a potential pitfall, we think read in the context, particularly of 7.1 and 39.3, that all it does is add a level of balance, as I said, between the rights of the regulator and also the various rights of the operators. So we would still be of the view that 7.1A and 39.3 should continue having the word reasonable included. I think Mr. MacDonald also raised a question or a concern around the rights of the inspector to enter particular premises. I think the assumption that's sort of underlying that statement is that it will be the operator that then makes the decision on whether it's safe or not to enter premises. That's not the intention at all. If anything, it's just to protect the actual inspector themselves. So it's not wording that's been included in there to hinder the powers of the inspector or to allow for safety to be used as an excuse not to enter premises. It's literally just to actually protect the actual safety of the inspector themselves and all of the other various parties that are going to be involved. There was a question raised on 27B, 32 and 66 with regards to wording around the determination of the fee. And yes, we did leave it blank on purpose because we looked at it again we know that obviously the RSR has got their own cost structures, expenses, etc., that they need to cover. So it's really difficult for us from the outside to be able to impose how we would actually determine the fee. I think what we wanted to just table to the committee is that as it currently stands, there's a potential risk that in determining the fee, the RSR could sort of go above and beyond, and we go back to that word reasonableness. So what would be reasonable in that particular scenario? So how much funding do they need for them to actually implement their functions and to carry out the objectives is the question. We don't know. We don't have sight of that particular information, but there must be some transparent way that can be regulated and at least set out in a way that we understand, and also we can have some sort of sense of what those costs will look like, what they'll look like in the future. There was a very interesting question in terms of whether there are additional risks and uncertainties in the current bill that's been put forward to us. From our perspective, I think would say that the main risk that we are concerned of, and I'll go back to the structure just so that we're all aware. So as a representative of the Bombela Concession Company, the risk that we've picked up, the uncertainties, that's what we've included in the presentation, and that's what's been set out to you. However, that's not to say that the Gauteng provincial government or the GMA will be presenting after us, or the turnkey contract or the Bombela operating company don't have their own particular interests and views that they would want to express. So it may very well be that there are other concerns with the bill, but from a purely Bombela concession company perspective, I think what we've highlighted are the concerns that were there for us that we've identified. In terms of the PFMA, I think to clarify, the statement was made in the context of the definitions. So it wasn't aimed at a broader discussion on the effectiveness of the PFMA when it comes to regulating triple P arrangements. We didn't look at that, we didn't consider that. The purpose of this submission was really just to highlight the fact that the amendments that we want to be included in the next round of the bill are adequately structured or will be able to be applied not only in the Gautrain project, but in any sort of PPP arrangement that's set out in the PFMA. So it was a lot more narrow, I think, than maybe how I've put it across. And then I think the last question again was on the fees and what sort of checks and balances could be put in place. Really, really difficult for us as a private sector party to try and dictate or determine how the state and state functionaries should implement their particular functions and how that fee determination should be calculated. But as I said in my previous answer, the main thing that we would look for from a private sector perspective is to have transparency in terms of the methodologies that are applied, so that we can plan and have certainty in terms of potential future costs. I think that's addressed all of the questions, Chair.
Thank you very much. Thank you, sir. With that said, let me take this opportunity to thank the Bombela concession for
Thank you. It's a pleasure.
the presentation and serious consideration of your presentation as we move towards the finalization of this bill. Thank you very much for availing yourself and making time to come and talk to us about this bill and show your interest. We will consider and do our best to include what we can include in this submission. Thank you very much. You are liberated from this meeting. Oh, before I liberate you, Sir Lucky Zondo had requested that maybe the presentation should be shared via email. Is that possible?
Yes, Chair, I think we already shared it. We sent it through to Valerie prior to the session. So, but we've got no problem in sharing the presentation.
The department has it, Lucky Zondo. The department should be having it. We have it as a committee. Yes.
No, thanks,
Somebody
Chair.
wanted to say something?
Thanks, Chair. I've just shared my my email here. That maybe they can just push it to I represent Satsao.
Oh,
We
you are
organize
out.
PRASA.
Oh, okay.
Yes.
Chair,
Okay. Yeah,
can
I
any?
I hear you now. Valerie?
Yes, Chair, the presentations are available on request. So if anyone wants it, they can email me at vcarlse@parliament.gov.za and I'll send everything.
vcarlse.parliament.za. Like you've got it?
I got it, Chair. Thank you very much.
Thank you very much. With that having said, you are then liberated. Thank you very much. You are released.
Thank you, Chair, and thank you to the committee and the members.
Thank you, sir. Honorable members, of the Portfolio Committee of Transport, Tawanda. Who's Tawanda? Okay, I'll talk to Tawanda as we come back. I want to allow a space for us to have a tea break. Am I right? No, I'm not right. Where are we? 10:10, or it's submission by Gautrain Management Agency. Right. Gautrain Management, are they here? Maybe it's Tawanda, Shamu. There we are. Thank you very much. Train. It means the train is from Gauteng and moving only in Gauteng. Can I get a face of the presenter so that I hand over properly? Mr. Shamu, are you here, sir?
Yes, Chair. I just did the presentation for Bombela. It's Mr. Khobe who's going to do the presentation for the Gautrain Management Agency.
Oh, okay. Tsepo. Mr. Khobe. Where is Mr. Khobe? Tell him to come through.
Chair, Mr. Khobe is
The committee is very
online.
friendly.
Mr. Khobe is online with the rest of the team.
I want to hear the voice, Ms. Carlse. Are we able to get him to speak to the chair at least? Tell him to unmute and talk to us. Railway safety bill. Mr. Khobese, can you unmute yourself, or he's drinking tea, but it's already 10:10. We can't have any other excuse that we are early or any other thing.
Okay.
Thank you
Let
very
me
much,
put my
sir.
headset. Can you see me, Chair? Can I
Clearly,
proceed?
sir.
Okay. All right.
Thank you very much.
Chair, if I can put my name is Tsepo Khobe.
You'll come back to me at 10:45.
All right. Thank you, Chair.
The latest.
Can I start?
Thank you, sir.
Is my presentation visible, Chair?
The cover of your presentation is in front of my screen here, so it's clear and visible.
Thank you, Chair. Good morning to everybody, and my apologies for the small glitches with the system earlier on. My name is Tsepo Khobe, and I'm the Chief Operating Officer of the Gautrain Management Agency. Mine, Chair, is a much simpler submission, but I will also clarify some of the issues that were raised by Mr. Shamu earlier on, and the reason why he was asking for reasonableness more than anything else. But let me continue with my presentation, and then I will then, in the time left, then come back to the issues that were raised earlier on to deal with them. Chair, I'm not going to waste your time. Mr. Shamu had given you the background to the Gautrain PPP and all of that, and have shown you all the players. I will just explain a little bit the reason for the structure, and then I'll go immediately to the specific comments on the bill, and then we'll deal with some few issues that relate to definitions that are in the bill in itself, and that just needs to be clarified or cleaned up as a whole from our perspective more than anything else. So, Chair, in terms of the PPP is brought in by a concession agreement that originally was signed between the Gauteng provincial government and the Bombela Concession Company. Now, one would ask, why was it not signed directly with the Gautrain Management Agency? At that point in time, the management agency did not exist. And therefore its powers were then delegated. I think it was in 2010 when it was set up later on after the project had already been started and was already operating partially on the link to the airport. The operations of the Gautrain, or the concession agreement itself, is due to expire in March 2026, and the Bombela Concession Company is responsible to maintain, operate, and actually manage the services inclusive of the station. And which means that exclusively they are the only ones who have the right to do that. Now, this is a structure that you have looked at earlier on, and the structure in itself, as you can see, the contract is run by us from the management agency perspective and is managed by us, and the assurance that presides over Bombela Concession Company is managed by us, but the contract is directly signed with the Gauteng provincial government, and our responsibility is for us to manage that. And the operating company then has a contract with the concession company. Now, the operating company is the actual operator of the system more than anything else. And what Mr. Shamu was raising as an issue, it's much more an issue of definitions, and I'll deal with the issue of definitions later on as I continue with what they call it, with the presentation in itself. So this is the structure. We have the GPG government in itself is the private owner and the owner of the system, and the assets that are on the Gautrain, inclusive of the trains, the buses, and everything else, actually belongs to the Gauteng government. And that is something that sometimes people tend to miss as a point, that the assets of the Gautrain are actually owned by government. We as the agency, we are then placed as per the GMA Act to manage and oversee the implementation of the Gautrain Rapid Rail Link, and then manage its assets, and then manage the contractual relationship between GPG and the concession company itself. And our responsibility lies on the long-term protection of the assets. And that is what our role is. And the day-to-day management of the asset is done by Bombela itself. And then from then onwards, we have a contract with the Bombela Concession Company, which is the contract that we manage. And their role was to design, construct, and finance the operating and then ultimately transferring of the asset. And then they then contracted Bombela Operating Company, who are the actual holder of the permit in this case. And the Bombela Maintenance Company does maintenance on behalf of the operating company. And then you have the subsequent parts of the concession agreement where the buses are operated by Unitrans in itself. So in general, the comments on the bill that we're raising is we are happy with 7.1 and 13D, which talks to the regulator to perform its function in a fair, equitable, and transparent and efficient manner, and the cost must be clear to us. And also happy with 33, which is the provision that cannot unreasonably withhold the approval of a safety permit. Chair, I want to raise an entire issue here that Mr. Shamu was getting when he was asked about why is he asking for reasonableness. In one night, I think it was 2018, we had to go and pick up our collective permit in a very strange manner because we had disagreed with the CEO of the RSR about fees he wanted to charge that were not material to the specific permit that we were requesting in that year. And a lot of what was raised by by Mr. Shamu asking for reasonableness. Yes, reasonableness is a very difficult thing to define. We believe these inclusions here for 7.1A, 13D, and 33, and also curtail the powers of the regulator to unreasonably withhold a safety permit, actually addresses those things. So there isn't a requirement for additional wording that talks to reasonableness. But we had raised these issues because that had happened to us where a fee that was not material to the approving of the permit in that year. What had happened is that we're in the middle of procuring additional rolling stock, and the RSR was asking us to pay a development fee that would have been paid 3 years in advance of actually them doing any work on the system. And with us understanding that we budget year on year and we budget on the years that on which something will occur, then the operator was then levied with a fee. And when we asked and we questioned the issue of this particular fee, our permit was withheld in that year because we were refusing to. We were not refusing, but we were asking for clarity for what the issues are in and around that permit. And we actually believe that these inclusions that have now been brought into the bill itself actually negates and actually fetters the issues of the CEO willy-nilly deciding, and when he gets questioned or he is asked for a clarity by operators and us as system owners in order they call it in Gauteng, then safety permits are withheld. And for that matter, that's where that comes from. But the new bill in itself and these inclusions that are now currently on the screen, we believe covers us well all around. And I hope that clarifies the issue why Mr. Shamu was asking for reasonableness. And we also recognize Member McDonald's issues about the inability for us to can provide for reasonableness, because by its nature, once you bring reasonableness into any clause, then in turn, you'll have to define what reasonableness is. If I can continue, Chair, to the different other comments that we bring in. Now, having been in the business of the railways probably for close on to 25 years now, that I understand where the different definitions of a network operator, a station operator, and a, what do they call it, and a train operator come from. These definitions envisage a point at which we will have vertical separation where the station operator or the network operator will be a different person, the train operator will be a different person, and the station operator will be a different person. The problem with them and their inclusion at the current moment, and with them not being clearly defined and them not being used clearly in the body of the, what do they call it, of the bill itself, is that they start to hang. And in Mr. Shamu's explanation, maybe when he was raising the issue of risk, is that in a space where we conclude one contract with a concessionaire to do everything, to operate the trains, operate the stations, operate and maintain the network in itself. Once you have these definitions that hang but don't get used in the bill itself, the definition of who the operator is becomes problematic. And what we are recommending here is that, yes, we understand where these definitions come from and what they're intended for, but we have to clearly define who is the applicant in terms of the operator, in the sense of us being a PPP that has a vertical structure, that has a combined setup. We would request that a clarity be brought on who the applicant for of the, what do they call it, of the safety permit becomes. And therefore, if you have a vertically separated system that then has an operator of stations, an operator of trains, and operators of the network, each one of these people will be clearly demarcated as being required to apply for the permit, or it would clearly be the one who operates the trains. And I think that is where the confusion comes up, Chair. And if I may bring on the clarity to the issue of what Mr. Shamu was trying to explain by saying that without it being clearly assigned that who is responsible for applying for a permit in a network like ours, then it becomes problematic when you have clear definitions like this. We're not saying that definitions must be done away with. It's just that the reasonableness or the bringing up the issue of saying who is the applicant for the operating permit when you have such a system that is vertically or horizontally separated, then it would really be appreciated in that sense. If I can continue, Chair. I think the other issues is more about drafting more than anything else. And in clause 12.4, and the syntax is a bit problematic, that it talks about the board being able to elect an acting chairperson of the board, whereas in essence, in the clear understanding of the act in itself, board members are appointed by, what do they call it, by the minister, and those powers where a board chairperson or a, what do they call it, or both of them are not available to be able to dispense with their duties, then we need to be able to make sure at what level does this application of bringing on a new chairperson and a deputy chairperson comes up. If they sit with the board, they sit with the board, but there isn't clarity in this particular clause. And it's more a drafting and a clarification that will create a problem long-term wise, Chair. Continuing on, the second clause also refers to, or the next clause that is a specific comment relate again to a drafting issue and the term of office and the conditions of, what do they call it, of the board members. And I understand sometimes in drafting one tries to make a bill to not be very long, and therefore in that sense try by all means to combine certain clauses. In this particular clause, the clause talks about succession and the planning for the retiring out of, what do they call it, of board members. But in essence, later on, it talks about the retiring out of board members, or the term retiring out is then used in relation to board members that are non-performing. Now, if the logic was to be separated out, that the idea is for succession purposes, at any point in time, a third of the board will be retired out based on their term of office coming to an end. And also the idea that the minister or whoever appoints the board can actually be able to retire out board members that are ineffective, or can be lay off board members that are underperforming. The ideas must be separated out, Chair, and the, what do they call it, to be able to create clarity on that the clauses are not related to each other, because as it sits right now, it looks like the minister is able to just retire out a set of people, and it's always based on performance evaluation and all of that. So probably the drafting has to be set up in such a way that clauses that relate to the retiring out of board members due to the fact that their term of office have come to must be written separately from the ones that relate to the issue of non-performance, and also the issue that relate to performance evaluations of the board, and all of that. The two should be separated out. And then from then onwards, then we start talking about the delegation of the board and the provision of, what do they call it, of it just must be written probably that a board must comprise of, what do they call it, of members that have the capability to can be able to manage a board, and has to be a multidisciplinary board in such a way that it then allows it the ability to can dispense and actually function properly in their duties. And therefore, we would like that to also be drafted in such a way that it clearly demarcates, the type of members that it must be brought onto the board itself, Chair. And I think in general, Chair, in the main, the bill is welcome, Chair, and it's an improvement. And we would, recommend that the portfolio committee does consider effecting the changes as proposed, Chair. I'll leave it there, Chair. That was my last slide. Hopefully I've bought you a bit of time.
Thank you very much, Tsepo. Yeah, thank you for giving us a bit of time. We're listening attentively on what you said, reasonableness, the reasons thereof. Let me hear if the same goes for my members. Please be on standby for any clarity seeking question. I'm going to the members as I do. I have the hand from Honorable Hunsinger, and I'm happy to say that is the only hand. Forge ahead, sir.
Thank you, Chairperson, and thank you for the submission. Chairperson, I strongly propose that we keep all these minutes in credit for the Gautrain representative delegation for future purposes. They might need it. Chairperson, thank you for the submission. I have two questions. Firstly, Chairperson, I would like to know from the presenter what in the current Railway Safety Regulator Act he regards as unreasonable. There was one reference about the development fee as an example, but what other elements in the current Railway Safety Act do they regard as unreasonable? Because there's constantly this reference and the context reference to the Railway Safety Act, and that the future dispensation should be more reasonable. So I'm putting this in contrast. If you could just mention elements in the current act which they find unreasonable. My second question, Chairperson, relates to the suggestion that the competency level of board members should be improved. There's reference to poor performance of board members and comments that they should function properly. Could I get an indication from the presenter what he would see as properly functioning board members and the functions which, from his view, he would expect from board members? Thank you, Chair.
Thank you very much, Honorable Hunsinger. There is an afterthought from Honorable Pete May. Let me allow that. Honorable Member, you allowed?
Yes. Can you hear me, Chairperson?
Yes, loud and clear.
Yeah. Chairperson, I travel about 4 times per year by train, Gautrain, to Centurion. It's a bit expensive, but it's excellent. But then from there by bus to my head office. But what I would like to know, the presenter said that the buses are operated by Unitrans, and the word Unitrans is unknown to me. Is it under the Gauteng Train Management Agency? I would like to know more about the Unitrans.
Okay, thank you very much. I see hand keeps on coming. Is there any other hand so that I close this list of hands? And so Honorable Mapena will be the last. Honorable Mapena, masithokoze emva kwesikhathi eside siyabonga mhlonishwa.
Angithokoze ngithokoze ukuthi bengithola namhlanje ekomidini. Ake ngibuze on I think it's on the issue of clause 12.4 on the statutory reference in the clause, the Gautrain Management Agency seems to have an issue with the chairperson and the deputy chairperson of the board, and I think to quote them verbatim, they seem to say that the current clause says that if the chairperson is not or is unable to discharge his or her duties, therefore the board must elect their own chairperson. Almost the same, must elect an acting chairperson, almost the same arrangement that we have within the portfolio committee. Whereas if the chairperson is not there, there are rules that we rely on that we can elect an acting chairperson within the board itself. But you also make some sort of a stark comments, rather strong-worded comments, where you said that it is absurd that the board should elect an acting chairperson. But obviously, this is an interim measure. We know that board appointments are obviously the responsibility of the department and the minister and all of those things. But in this case, where you have an issue that you need to deal with, and for some weird reason or for a reason which obviously can be provided, the chairperson is unable to do so. But now a board is there, is fully functional. The challenge that we have is the chairperson who's unable to discharge their duties. Why is it then? Why would you go and use choice of words and say that it's absurd? Because in any event, the board recruitment process, it's a process which is it's quite an intense process, where there's advertisement and there's also different people that are interested in those to be appointed in the board. They get to be vetted, interviewed, and all of those things. So then the reasoning would be to say that whoever gets appointed, who's part of that board, in essence, would be in a position to discharge their duties and that they qualify fully. And obviously, with institutional memory as well, if having served in the board, you know what has been the discussions and everything else within the board. Why would then you go and use such strong language to say that it's absurd for the actual board to appoint an acting chairperson? We're not talking about a permanent chairperson in this case, because obviously that's a separate process. But in this case, we're referring to the acting chairperson.
Thank you. I thought that point is well made. If there's any other point, let's go to it.
Chair, with your indulgence, can I respond?
No, let me just get clarity. Are you done, Babu Mapena?
Chair, I agree you intimidated me, so I must be done.
I was just saying the point of upset, I thought is well captured. If that was the point, with all the humilities, maybe let's allow him to respond. Thank you. Back to you, and the Tshepo Hobe.
Thank you. Thank you, Chair, and what do they call it? And thank you for the indulgence on the questions on what do they call it. Remember, Hansinga, the issue on reasonableness and what we found to be very difficult, and that was the issue that I was raising. There was a regulation on development fees, and development fees were intended for anybody who wants to change their system or add additional rolling stock and anything of that sort, or doing additional planning for railway lines and buildings in and around an existing railway lines, needed to pay a particular fee. And that fee had a very complicated table that you couldn't ever be able to be clear how much money you were going to pay. And it's not a question of unreasonableness, but it's just that it was arbitrarily designed, and we never had an input to that, because the first time we saw it was when we were doing our additional rolling stock. And that in itself became a challenging issue when we asked, how is the fee determined? What is added? What is extracted? When does the fee get charged? At the point when the fee was charged to us as a, what do they call it, as a developer of the system and the owner of the system, we were probably 3 to 4 years away from where the RSR would have any real work that they would be doing. And in essence, we were being requested to pay that amount immediately at that point in time. And to us, we found it unreasonable that we could be, we were asking simply that because there is no particular activity of the RSR immediately now in the phase that we are on in terms of the requirements of the RSR Act. Why is it that we're paying this particular fee? And to us, that's what we found a bit difficult at the point when we were dealing with the issues back then. In general, the general other part of what okay, there's somebody who's unmuted, Chair. I don't know. So the other provisions, we found them to be functional, but we just are asking that, you know, in this part of the development fees and how the development fees are linked up to any particular application for a permit needs to be brought in line in such a way that it then identifies when the activities of, what do they call it, of the RSR are going to occur, and therefore we budget accordingly on our projects and our future planning to be able to make sure that we can pay these fees, and they are clearly demarcated what we're paying for, and where we found them to be like, maybe probably reasonableness is a very strong word, Member Hansinger, where we found them to not be clear, all in all, was how the fees were applied. The second issue on, what do they call it, on the long-term planning, and it was a suggestion, is that the board comprised of, what do they call it, of a multidisciplinary team. So in essence, you would have to bring on people with engineering skills, people with operating skills, people with skills that actually mirror what you find in, what do they call it, in railway operations and in the development of railways itself. It is purely a suggestion, Chair, more than anything else. We are asking more for a multidisciplinary team, people who have, you know, the know-how in financing and management of railways. And similarly, in our case, we would love for, what do they call it, for an addition of people who have PPP and understanding of PPP regulations. That's the diversification of a board as we are requesting. Member Peter May's question was very simple. Who is Unitrans? Unitrans is the company that it comes in the form of Mega Express. It's still all Bombela, it's still all Gautrain. It's the different subcontractors that get brought on. The Unitrans is contracted directly to Bombela Operating Company, and in turn, Bombela Operating Company is contracted to the concessionaire, which is BCC, the Bombela. It is a particular company that's a subcontractor. It's nothing to worry about. It's not a separate company. It is a separate company, but in this case, it's operating as the Gautrain and as the operator of the buses on the Gautrain. The question from Member Mabena Mundwanketu, where, you know, without adding the word that this is a temporary measure, and remember, we are only simply suggesting, Chair, with his clarity that he has just brought on now, maybe probably, what do they call it, we were hanging too far out of the window to use the word upset. But in essence, without adding the word temporary to that particular clause, that this is intended as a temporary measure while certain processes are occurring, that clause might be misconstrued to mean that, you know, the board has the rights to then be able to appoint their own setups going forward, Chair. And therefore the suggestion should be able to settle first. Let's withdraw the word upset. I think we're taking it too far in order they call it, but it was in our understanding that because the minister is the one that makes these appointments, without adding this to be a temporary measure, I'd say on, you know, when you read certain clauses, they have to be read in the context in which they occur. On the basis on which this is a temporary measure, then the board will then appoint a temporary chair until the final appointments are made. Then it clarifies the issue, Chair, and then the word upset then is not really required, Chair. And with the clarity of what Member Mabena has brought in, then it now becomes clear. But from the reader outside, without not understanding it as being a temporary measure, it might be misconstrued the way we had brought it up. And therefore, you know, Member Mabena, I request your indulgence that the word upset be withdrawn as such. It was us not being able to understand that this was intended as a temporary measure. Chair, I'll end there.
Thank you very much, Dr. Tsepo Hobe. Thanks for the presentation. Likewise, we will interact with the presentation as we move on. Consider the inputs, and thank you very much for making time to talk to the portfolio committee. We really appreciate that effort, and you are released to do other work, and thank you very much. Thank you, sir. Now, where are we now? Discussions done and dusted. We need to take a 10:43 to 11:10. Can we agree on a break, honorable members? We need to take a comfort break for 10 minutes and 10 minutes. Can we then come back at 5 to 11 and continue?
Agreed, Chairperson.
Thank you very much. Being progressive, Bauma Baba. Agreed.
Chairperson, I won't be hostile to your leadership, so I agree.
Thank you very much.
Agreed, Chair.
5 to, let's come back. Okay, let's come back. Thank you.
Recording stopped.
Mr. Akwate, I see you are online. Can you hear me?
Yes, I can hear you. Can you hear me? Good morning.
Yes, I just want to know, are you going to do the presentation on behalf of PRASA? Mr. Akwate.
Moloko Machaka. Le guy Machaka. Passenger Rail Agents of South Africa. Ribita Prasa ka khutshwanya ka pono mpa o dumedisa fela.
No, it's a department.
Oh, dumela o phetse hantle Machaka.
Department chairperson.
Thank you very much, man. Can we get a submission by Passenger Rail Agents of South Africa? That is PRASA. Are they here? Valerie?
Yes, Chair, PRASA is here.
PRASA is here. PRASA, are you here? PRASA? So they don't want to talk to me.
Recording in progress.
This
meeting is being recorded. Recording in progress.
Gafis.
Chair, yeah, we are present.
You are present. Okay, if you are present, let's allow you to present your submission. It's now 11 o'clock. I take it it's 11. It's 2. Please come back at 20 to 12. We can see you. You are organized. Who is presenting?
Chair, my name is Jacob Raffatet, but I'm the president of the GCO and the chairperson, and the rest of our colleagues. So if you like, I would like the chair and the just to have an introductory, and then we'll take it there. Then we'll kick off.
Go ahead, sir. Please go ahead.
Good morning, Chair, to you and to committee members. It's a pleasure again to come back to the committee and to come present, and thanks for the opportunity. With me here, I've got the chairperson of the board, Ntatera Matakane. I've got the team here of executives that are responsible for this item, the rail safety bill, the nominated manager, Ntatera Kemba Mahenye, our GM for strategy, Anna Marie Laber, our acting CEO of rail, Ntatera Malepane.
It's 11 hours.
And then I've got Ntatera Kane in the room. But as we said, Jacob Raffat will be leading the presentation to the committee members. And through you, Chair, will allow Jacob Raffat to present on our behalf.
Person on a point of order.
What is the point of order, honorable member?
Chairperson, there is an unbearable sound that is coming from, I don't know whether it is coming from the room where the colleagues are seated, but it definitely does not augur well for our ears, and as such will obviously affect our concentration on the presentation.
Thank you, honorable member. Please take note of that sound, otherwise we are good to go. Over to you, sir. Can you please start?
Thank you, Chair. Thank you, members of the Portfolio Committee. I hope you can hear me. In case there's not audible, please indicate.
It's much better. It's much better now. We can hear
Thank
you.
Chair. Thank you, Chair. I'll proceed. And we thank the Portfolio Committee for the opportunity to present certainly our comments as Prasa. We intend, Chair, to deal with principal issues we have presented to Parliament, the detailed comments. In this presentation, we'll deal mainly with the principal issues that we'll deal with in a short while. One of the issues that we like to highlight, certainly stemming from the bill, is the rail security infrastructure. As you know, I think it's a known fact. The infrastructure has seen unprecedented levels of vandalism and theft. We believe that the bill should obviously reflect on it, so that there is a fair amount of attention being given to it. What you're suggesting, Chair, and what we intended to do is just to present our presentation set out in a problem statement. We call it a problem statement, just to highlight the issues that we want to bring to the committee's attention, and then we then obviously make a proposal as to the solution. So from a security perspective, and given that the rail infrastructure is a national asset and critical to the economy and the movement of people in South Africa, we believe that it should obviously be accorded the same amount of security that's required. We then say the railway police should obviously be dedicated to ensure that that infrastructure is protected, certainly in the national interest and as a backbone to economy and movement of people and goods. That railway police should then have appropriate training to deal with a number of issues, not only just to look at the security related death, but to ensure that appropriate and timely measures are put in place. That would obviously include prevention of invasion of our rail reserves, to make sure that crimes against the infrastructure are properly classified. The railway police that we call for is obviously to ensure that it accords an equitable and appropriate attention to the requirements of rail infrastructure and its criticality to the national interest. Chair, what we're suggesting certainly as an additional measure that the bill should obviously ensure cooperation and interoperability between major operators, especially all SOEs, to make sure that resource allocation for security operation across the rail infrastructure are given the same standards, and that the regulator is empowered to issue directives to ensure that there's cooperation in the industry, especially among the SOE, that the security standards that are required for protection and designation of critical infrastructure are then issued by the regulator. We obviously call for interface between relevant authorities ensuring that rail infrastructure is protected. That includes the police, the metro police, to ensure that there's a dedicated, at least attention to make sure that rail infrastructure is then protected in that interest of national security, and make sure that the economy is not distressed by vandalism and theft that we've seen in recent years. So one of the issues is obviously safety standards. We call for common safety standards across the board. There's currently obviously a SAN standard 3000, which is a known regulated safety measure within the industry. We call that should be the sole measure of safe operations within the rail industry. It's a South African standard, and we believe that it is adaptable to improvement, to accord with improvement within the safety standard and development of the safety management system. Therefore, we believe that it should be the sole measure and the basis for the development and implementation of the safety management system, the so-called SMS. It is certainly we believe that as a national standard, that should serve as a basis that will then create that legal certainty that we require in the rail environment. From an application and continued operation of safety permit, we would obviously like to bring to the attention of the committee section 35B of the bill. It says a framework where an approval from an application perspective by the regulator must be considered and determined. There's a 30 or 90 days, depending whether you're a new applicant or an existing permit holder. What we're seeking through that, through our proposed solution, is that the bill should obviously should distinguish between new entrants as well as current operators. We say that clearly because there are certain cases where the permitting application process does not dovetail with the issuance of a new permit, especially for the current operators. Then that creates a difficulty from a regulator perspective, because they have to extend an expired permit, which obviously is not underpinned by the law. So and from an operator perspective, there's a risk of criminality stemming from the new section 30(b) of the Act, which says that no operator can operate without a permit, otherwise that's a criminal act. And obviously the impact from an operation is that we may stand to lose an insurance cover to an extent that insurance cover, and usually it's predicated on operator having a valid safety permit. Therefore, what we suggest is that the bill should indicate and prescribe a timeline for communication of the outcome of a safety permit. It says 90 days, but as indicated, sometimes it does not dovetail. What we ideally would like to have is that the bill should then indicate a time period within which the
Chairperson. Chair. Mangati.
Yeah, Baba, yeah, Baba.
I'm sorry to disturb. The slide is not moving.
Yeah, no, that's
apologies, Chair. Sorry, we've been talking on assumption that it is moving. We'll fix that in a second.
Thank you, Joby.
Let me close the motion, Teddy.
Oh, it's moved now. Okay. Decision.
Uyasibona Jobe siyamove.
Chair, would it be fine if we present it in that mode, or would the committee members like in a presentation mode? Sometimes it may be a difficulty of, can we leave it as it is if the chair and the committee accept it?
Yeah, accepted. It must just move with what we are saying.
All right.
It's rather
All right,
small
thank
in
you.
this. Can we get it in presentation mode, please, Chairperson? The writing is so small in this mode. It's not intended to be presented like this. Presentation mode, please.
On our side, it's on a presentation mode. On my computer, it's on a presentation mode, but it appears that there might be
Can you enlarge
configuration.
Enlarge your
Just move from presentation mode and let's see if we can enlarge.
Are you in PowerPoint or PDF?
right. Thank you very much.
We're hoping it's much better.
It's much better. Honorable Member Unsinger, are you happy?
Thank you, Chairperson. Excellent. Can we proceed? Thank you.
Thank you very much, Chair.
Apologies for that, Chair and committee members. So what we're proposing in addition is that we would like to build then to propose that the current operators, especially the holders of the current permit, that upon expiry of the permit, and assuming that an application has been done and there has not been a response from the regulator within the 90 days, then the current permit must then extend by operation of law, either to a fixed period, or the regulator will then be deemed to have made a pronouncement. So one of the suggestions is that the period for consideration of an application should then be extended by operation of the law for a fixed period of time. For example, the bill should then propose that if within the 90 days there's no determination that has been made by the regulator, it will then trigger an extension, especially for the current operators. One of the issues that we would like obviously to bring, this is one of the issues that we have, under transitional proposal or transitional arrangement that must be put in place is that the current permits that have been issued under the National Railway Safety Act should automatically be deemed to have been extended to a defined period. That immediately after the bill has become law. There's no provision for that in the current bill. So what we're seeking to do is that we do not have to raise a process to keep our permits alive. Another issue is obviously suspension of permits. What you raise under section 33(6) is that it then provides that a permit can be suspended for reasons other than related to safety matters. So section 33(6) says if we fail to pay a levy or a fine, the permit can be suspended. We then propose that suspension or revocation of a permit that has been properly issued should be orders of last resort. So we should not be suspended from operating as our legislative mandate for reason only that we have failed to make a payment of a fee or a levy. The regulator is not without recourse, certainly, because it has an inspectorate which has authority to issue safety improvement directives, contravention notices, and penalties for non-compliance. Therefore, we believe that section 36(3) should be deleted. The review of the safety condition, Chair, we believe that is tantamount to self-review by the regulator. So the principle of functus officio wants certainty. So we believe that once the conditions of the permit have been issued by the regulator, they should remain, because that gives a sense of finality to us as operators. At the moment, currently section 32 allows self-evaluation by the regulator. We believe that it doesn't fit nicely with the framework of the legislation. The whole purpose of the permit and its condition is obviously looking backward and focusing the condition that will be applicable going forward. We believe from an interim, once the permit has been issued, the regulator would be obviously be able to regulate non-compliance through the inspectorate. And therefore, we believe that section 31, subsection 2, 1 and 2 and 3 and 4 should be deleted. We've obviously indicated that we, as an operator, we may be under section 32 in bracket 5, apply for an amendment of the conditions, but we would like a specific provision to enable us to cancel certain special conditions, provided, of course, that we have fulfilled them in terms of the conditions that have been inserted to a permit. The board's authority, the bill obviously grants certain authority to the board to do a number of functions. We believe that certain of those authorities should not be capable of delegation, certainly to the CEO and other operational functionaries within the regulator. The difficulty is that it then obfuscates the separation of the board and the regulator. And the CEO, as you know, and the other key operational functionaries are the regulators, and they possess that regulatory function. We believe that section 14 of the bill, which deals with certain decision of the board, section 35(2), which deals with determination of policies for registering of payment institution, section 37 of the bill should not be capable of delegation to the regulators functionary, other than, of course, to a board committee. The regulation, the bill proposes licensing and accreditation of service providers. We believe that the difficulty that it brings is that it then provides, in itself, in its operation, it creates a difficulty in terms of conflict. A conflict that arises from the regulator licensing safety critical grades, and at the same time accrediting the service providers that obviously provide the required training to the safety critical grade. Our proposal is that the licensing of safety critical grades should be left to some standards which obviously regulate how safety critical grade and the relevant vocations under safety critical grade. We believe that the role of a regulator in licensing of safety critical grade and accrediting the service provider may lead and create an appearance of conflict. If there's a need for accreditation of a service provider, we believe that should be a function, ideally, of the qualifications of authority and not the regulator. as we obviously the regulator can then place reliance on an influence of such independent service provider accreditation. The protection of information, there's a provision, section 40 of the bill creates a leeway for a regulator to determine the disclosure of information which may be regulated under POPI. We believe that that is unnecessary, certainly, because the POPI in itself, and to an extent that it regulates personal information, that it should be the sole determinant of how that information should be dealt with. So effectively what we're saying, Chair, is that information that we provide to the regulator, which includes POPI impacted information, should then be kept confidential by the regulator, and the regulator should not determine whether that information can be further processed, because those regulations are dealt with, we believe, by a specialized regulator as the information regulator is. So therefore, there's no need for section 41 and E, or section 40E of the bill, and the consequential residual application under section 40 and 2 of the bill. We believe that the information regulator should adequately, or at least the POPI Act adequately deals with how we should process that information, including that information as it's passed on to the regulator. We have spoken about transitional arrangements, certainly. We believe that the bill must provide for adequate transitional arrangements, particularly those that relate to the current operation under the safety permit, the issues about in-house training facilities. So we believe that the current in-house training facilities that are providing training to safety critical grades, that there must be a dim existence when the bill comes into being. Similarly, if you're an operator under the national, under the current legislation and you hold a permit, there must be a transitional arrangement with a deem that your permit will carry on even when the bill comes into law. So that is important clearly, because certain sections, certain conduct, certain typical example, we can't hire a person to provide safety critical grades if that person is not registered in terms of the bill. So if we do not create that transitional arrangement, we might have a difficulty, and that people may face criminal liability, with unintended consequences of application of that particular section. So we believe that there must be a provision for a transitional period. The authority to determine policy for registration, there appears to be an overlap. So we've looked at sections. I'm not sure if my slides are moving as I go along. So it might be that I've missed a couple of slides.
And carry on.
Okay. So there's an overlap as to who determines the policy for registration in the bill. So in one section, it appears that it's the board that determines that. But in another section, it then indicates that it is the minister who determines through a gazetting process that the policy insofar as the policy regarding registration and registration of an accreditation of service providers. So here we're struggling with connectivity, but hopefully it comes through.
Hello.
So we're struggling with connectivity to show you the slides, but we're working on it. I can talk in the meantime, but I think it will not. It will be ideal that you see the slides as we talk through them. Asking for indulgence.
Valerie?
Chair, if there is a little bit of a challenge on the process side, can we do it from our side then?
I see the slides are back on the screen. Are you good to go, sir? Or you want us to help you on our side? And
Right. I'm on a presentation mode. Let us try, give it 1 second and just see. Otherwise, we may ask Valerie to assist.
Yeah, that's what you're presenting.
Okay, I'm presenting from slide 14. I'm hoping that you can see the problem statement starts with the bill to clarify whether the board or the ministerial authority that overlaps. That was the issue that I was discussing in a second. Yes, so we're saying there's a bit of an issue setting as to who holds the authority to issue the policy under 35(2) as well as under section 68C and D. So we then propose that the bill should clarify whether the board or the minister has the authority, or if there's an overlap, what are the respective authorities insofar as setting the criteria for registration of training institution. Just then, I'm on the next slide that deals with appeal and the process of appeal. What we're seeking to achieve through that problem statement is that ordinary and appeal suspend the decision that is subject to appeal. Section 54, 55, and 56 does not give a sense that is the common knowledge that is known in legal jurisprudence and fairness, that the effect of an appeal to suspend a decision that is subject to appeal. We want the bill obviously to accord known common procedural rules so that we know that when an appeal has been lodged with the regulator under those sections 55 to 56, that the effect of that appeal would then have the effect of stopping a decision that has been taken. We're mindful that may be subject to abuse, but for that we suggest that the bill should then specify the grounds for appeal, which would obviously will help with whether with the process of knowing when to appeal and when will appeal lay with a decision and the type of decisions that will then be susceptible and be open to appeal by an operator. Okay, the bill intends to create a number of new criminal offences. The only difficulty, and we briefly that discussion, was indicating the difficulty that the bill seeks to, those criminal offences, the new criminal offences. The bill has in place certain offences that are created certain by strict liability, where no intention is required. That position we believe is undesirable, especially when it has a sanction of imprisonment. So we indicate that many of our employees certainly that they are creatures of delegation and job certification. And based on what we see, we believe that if criminal liability is predicated on a strict liability, that may raise questions for a number of our employees. And I'll deal in detail with the type of criminal offences that are created in terms of the bill. But the bill proposes a vicarious liability or principal agency liability as a basis for criminal liability. So effectively, it says if an employee who might be deemed to be an agent in relation to a principal does something, that liability can be on a basis of vicarious liability be extended to the principal. There's a difficulty as to what is a principal and agent in an employee-employee relationship. Although the bill does go into details about, it does indicate that an employee or an agent may attract liability to an employer or a principal. The issue that they're not clearly defined, certainly in our eyes. Secondly, the sanctions that are proposed. Certain sanctions that are proposed in the bill may not fit the crime and may not be appropriate for certain crimes that are created in terms of the bill. In our submission, that for purposes of the criminal sanctions, that a maximum of 12 months imprisonment with an alternative for a fine should be considered in the bill. We now deal with different criminal liabilities that have been written in, or whether the bill proposes should be written into law. One is a crime of failure to report an incident. We believe that that obviously will raise a strict liability if there's no intention sought for such a crime for such a crime to exist. One of the bill proposes that a maximum of five-year sentence should be imposed for failure to report an incident. We believe that the crime should be based on a demonstrable and willful intent to avoid a reporting or a reporting obligation. Therefore, the intention must be the basis for such an offense, and that the maximum sanction, as indicated, should be 12 months with an alternative for a fine. There's a crime of interference with an investigation that is proposed under section 43 in brackets bill of the bill, and it has a maximum sanction of 5 years. We believe that the sanction is harsh. It is our submission that a 12-month imprisonment with an alternative of a fine should be sufficient. In the next slide, which will come through, the bill proposes single director liability. This is the normal requirement for a director normal requirement where directors are expected to act in concert. The difficulty is that the bill does not indicate when would a single director be held individual liability for individual liability, and we go into details as to why we believe that a single director liability should not hold and should not be included in the bill. Liability for a director is imposed for a single director, notwithstanding that ordinarily operations within our environment is delegated to management. For example, appointment of staff, it's normally an operational matter which is done by management. Based on a single director liability, a director may be liable, and there's obviously a crime specifically that deals with hiring of safety critical grades that are not licensed. So I believe that it probably might be harsh to expect of a single director to be liable, setting on the basis that management failed to do what has been delegated to management. Therefore, we believe that the bill should, that no director a single director should be held liable, unless, of course, that director has been delegated responsibility by the entire board to do a specific function. The board expected to act in concert, so to single out a single director might not be in court with that principle. We believe that a similar principle as the business judgment rule should be adopted for purposes of the operation of director. If there's any criminal liability that has to attach to a board, it must be based on the principle of business judgment rule, which requires that the board must act in the best interest of an organization, and that if they fail to do and they fail to apply themselves, that they would then be deemed to breach the business judgment rule, which probably might present a better basis for such criminal liability. There's a phrase in section 59 which expects a director that a director must take all reasonable steps to ensure that an entity does not commit a crime. We believe that given what we've said about delegation of authority and the fact that that principle of taking all reasonable steps might be requiring a director to be actively involved in the operations of the entity, which obviously goes against the known principle that the King IV pronounce on, i.e. that directors must be strategic. So therefore, we then say if that is the case and that section 59 is left in the bill, it will then force the board and individual directors to then be operational and to take over those responsibilities, because that might draw liability to their function based on a single director's liability. So one of the issues that we want the committee to consider is section 59, that term all steps, that it may raise difficulties of interpretation. We rather believe that if it's removed, it doesn't take away that responsibility, because it will say the director must take reasonable steps to ensure that the entity does not commit a crime. And therefore, I think it's more palatable setting from the role and expectation of a board. Chair, we then carry on. Section 58 of the bill requires a vicarious liability on part of on a principal and agency basis. We believe that section 58 of the bill is at odds, obviously, with the requirements certainly of criminal liability. Criminal liability should not be stemmed from vicarious liability. Clearly, because we believe that the base of criminal liability must require the purposeful and willful intent on the part of the chiefs. Chair, I'm hoping with all the difficulties that we have that we managed to share the most principal issues that we wanted to bring forth to you, the chair, and members of the committee.
By so saying, I guess you are saying thank you, you're done. Am I correct?
Yes, Chair.
Thank you very much, sir. And your team of PRASA, Passenger Rail Agents of South Africa. Honorable members, I am coming to you now to do your due diligence on the submission. I see only one hand, two. Okay. We only have two hands. That is Honorable Chris Hunsinger and Honorable Tamsanga Mapena and Honorable Pete Moye. These will be the hands for this presentation in that order, please.
Thank you, Chairperson, and thank you for the submission from PRASA, also for the presentation. My first question of clarity, Chairperson, is based on slide 6. Slide 6 addresses the issue of timeline application process. My question there is, can you give us clarity on the position that you have with that with regards to permits and the fee structure and the balance which is so necessary between the business plan of a railway safety regulator versus safety? Because what we have experienced is a decline in safety, really serious safety conditions that continuously keep on in your operations, particularly in the metro rail environment, and that fines do not seem to be effective. Can we get your comment on that? The next question, Chairperson, is on slide 17. And the issue there was around the failure to report transgressions. And the solution then from PRASA is to have less harsh sanctions. Could you give us your impressions around the safety elements, which is really important, and then your position in proposing less harsh sanctions? The final question, Chairperson, is based on slide 18, where it is about section 59, and the issue around all steps that should be taken and the particular interpretation of all steps. And then in the solution, the presenter presented a contrast between a undesirable requirement between quantitative matters and qualitative matters. Could you please expand on that? But then particularly around why you found it necessary to bring the King 4 report into this, and how the King 4 report would then relate to, you know, all the steps and the roles that you emphasized there. Thank you, Chairperson.
Thank you, Honorable Chris Hunsinger. Honorable Mabena.
Ngithokoze Sihlalo, ngithokoze ithuba engilithola go to portfolio committee. Chairperson, there is maybe just a few questions for clarity. I think the first one emanates from slide 3. In the proposal for a railway police, but in the proposed solution does not really, I think, assist in terms of what is it that you are asking the portfolio committee to do here? Because I understand that within PRASA, there is a component where you have your own railway police or railway security arrangement that you have, which are internal within PRASA in terms of the operations. But here we are saying that you want to propose railway police. Do you want this to be a specific unit within the SAPS? Because you say here that you therefore want government to intervene, and that this should enable equitable access to railway police, who will be, and you detail why that should be. Do you want this to be a branch of the SAPS or a component of the SAPS where they come and provide those services? And then if that is the case, then we are saying that the cost of actually securing the railway network lies squarely with the police, and that you are, as an operator, you want to remove yourself from that. Secondly, I think on slide 4, here you are, I think this is an overreach, if anything. You want to propose that the regulator should encourage the interface between other operators and other state-owned enterprises. But now the question is, what is stopping you as PRASA now from collaborating with other SOEs and other major operators in terms of ensuring that you can secure the railway network? I mean, in terms of establishing relationships with the SAPS, intelligence and everything else, because you also, in the same slide, you also say that there are limitations in terms of what you can do in terms of intelligence gathering, capacity and resources to deal with vandalism and all of those things. But my question is, what is stopping you now outside of the bill? Because I believe that's is an operator's responsibility, and I think you can initiate those relationships and ensure that you can secure the revenue. Why should the bill specifically force and encourage cooperation, including resource allocation for this? And then if we move then again to, because we are also here saying that you want to, you want the bill itself to force almost to issue directives to cooperate within the industry. Now, why should a bill force players within or operators within the industry to actually collaborate and work together? Isn't that a function of management where you go and establish relationships, build rapport, and ensure that issues of mutual interest in terms of the space that you find yourself in or within the sector? Why should there be almost like forcing these industry players to cooperate with each other from the bill itself? And then you're also here raising the issue of the adoption of I think in terms of the safety management standards that I hear, the safety management system, you're asking the bill to force the board to adopt the SANS 3000 series. Now, my question is, why would you then want again to force that this should be in legislation? What is stopping you as PRASA from currently the regulator, approaching the regulator and asking them to adopt the SANS 3000 series, which is a safety management system currently? And if there's nothing, what have you done? Have you taken any reasonable steps, or have you tried to also lobby some of the industry players, which are the operators, to establish a relationship with the regulator to ensure that this can be adopted. Because you seem to argue very strongly that these are a known and uniform, a recognized set of principles that underlines regulation of safety within the railway industry. And you seem to believe that the SANS 3001 series is one that can assist greatly in terms of securing the railway network. So now I am asking, what have you done so far? Now let's move on to the other issue. You are asking the committee, or you want the bill to consider the prescription of a timeline in terms of the safety permit application, in terms of the outcome, that you preferably would not want, or preferably you want not less than 15 days prior to the expiry of the current permit if an operator is applying for a renewal. Currently, what is the timeline that is there? Because I see here that you are saying, yeah, but you are asking for 15 days. I'm saying, what is the current timeline, and what is the problem with that timeline? Because here we are raising issues of the expiry and all of those. Now, if we move on to slide 7, of which I feel is greatly problematic, because you see, I mean, in the first bullet point here on the proposed solution, you are seemingly saying that if the regulator has not come back to you, therefore you want the bill to say that the regulator has, or be deemed to have made or stated a pronouncement in terms of section 35B. You know, and this is for a safety permit within 30 or 90 days. Here is my contention with this issue. If the railway safety regulator has not come back to you within the time that you want them to come back to you, what if they are finding material breaches in terms of your application, or in terms of what they're considering for them to give you a safety permit? And what if then they're still busy with that, and they're trying to ensure that those issues are addressed? Why would you then put them in a situation where you're almost making their work to be obsolete? Because if then they're still busy doing what they need to do, taking due diligence, why would you then push that the bill should say there must be a deemed or stated pronouncement? Then it means now that any operator can make an application, and if there are issues which they fundamentally differ with, or they're failing to comply, therefore they should just stick it out and wait for a deemed or to have deemed or stated a pronouncement, even outside of what the RSR maybe would have wanted to do. My last comment is contained in slide 8, which is also, I feel, is a bit problematic as well, because here we are saying that the suspension of the safety permit, we are saying that the regulator must not suspend the safety permit, because you seem to believe that a safety permit outside of issues which have to do with incidents. But now, if you fail to pay the levies and the fees, and I think this goes hand in hand with user pay principle, you are aware that the regulator has to collect some of these fees and levies, and these are the lifeline and the lifeblood of the regulator. Why would you then, because if we agree to that, we are seemingly then going to say, we can now allow you to get away with not paying the fees and the levies. And what mechanism does the regulator have to hold you accountable? Because if then they revoke, or they don't give you a safety permit on the basis of non-payment of the fees and the levies, then that would actually encourage you to actually make sure that you honor all the payments and the duties which are due to the regulator, because this is part of those things. And also, even if the regulator was, even if maybe we were to agree with what we are proposing here, I mean, for 2018 alone, there were, I think it was 9,032 incidents no, 9,034 incidents. So that on its own should tell you that even if you had not paid the fees and the levies, the regulator, I mean, there's sufficient grounds in terms of incidents for them not to issue the safety permits and everything else. And I think one of the issues that you were contending that I think
Are you wrapping up, Honorable Pena?
Yeah, I think one of the issues that you were raising here, I think one thing that we have a challenge within government is that no one can really be held accountable. And you seem to be contending the issue of managers being held personally liable for their failure to execute their duties. Now, you want to convince us to say that that should not be the case, whereas we're having challenges currently within SOEs, government, and anywhere else where people are not personally held accountable, and that these should not be subject to criminal acts. We should then encourage them that they should actually comply. So those are some of the issues that I wanted to raise. Perhaps maybe you can give us clarity in any of them. Thank you very much, Chair.
Thank you very much, Honorable Mapena. Honorable May.
I've got a problem with my video, sir. Chairperson, I'll be short as always. I've said it many times in portfolio committee, bring back the South African Railway Police. This is the only way to stop vandalism. We want to see railway policemen on railway stations and trains. The criminals destroyed Praza. South African Railway Police must prevent crime and not only investigate crimes. If you look at the railway stations, shortage of trains as a result of electrical cables stolen, the economy lost billions, not millions of rand. And I disagree with my colleague, but a South African Railway Police must be an entity on its own and not part of the SAPD, because the SAPD, they're also in trouble. They can't handle their own cases. Thank you, Chairperson.
Thank you, Honorable Member. Piet May van Ooskap af. Prasa.
Chairperson, just as the last, I'm not sure if you can allow me. Maybe just 15 seconds. You can time me if needs be.
Okay.
Thank you very much. Chair, I think, let me take advantage of the platform here now that we have Prasa board here in the meeting with us. The issue of the ongoing Prasa or Prasa protection officers, which is not being resolved, is creating a problem on the ground, because there are people who are seemingly scamming people, asking them for money for them to be given jobs in terms of the being made permanent. We opened the criminal case at the Johannesburg Central Police Station yesterday against a certain Mr. Hudson Rantimo, who has been soliciting 1,000 rands from people, promising them that he is going to make sure that they are employed permanently. He's working part of the VUCC's security company. And I'm not sure if maybe, obviously, the people who are in the room, they're in the boardroom, I saw there was a big delegation. Are they giving this issue any attention whatsoever? Because seemingly, those contract security guards which are being passed from security company are falling victim to this. About 78 of them paid those 1,000 rands, and this person ran away with that money. But it shows that the workers on the ground are very much desperate to be made permanent by Prasa and all of these things. And we have opened that case. We assisted them to open that case at the Joburg Central Police Station. Mr. Hudson Rantimo, if maybe they can look into it. I think he's employed by VUCC's. Thank you.
Thank you, Honorable Mapena. You had said I should time your 15 seconds. I think you are raising a very important issue. I don't want to regard it as a side issue because of the submission. I would want to request Prasa to make a follow-up on this issue and give us a report back as soon as possible. I'm sure the department is also listening. Prasa, on the submission, can you quickly deal with the clarity seeking questions that were posed on you? Back to you, Prasa.
Thank you, Chair. I hope you can hear us. We note the consent, the last consent that was raised by Honorable Member Mokena. We propose to deal with the queries on a slide-by-slide basis in that order. So to an extent that I may, in the presentation or at least in the response, have missed any question, my colleagues will obviously assist me to that, to that extent. I propose to deal with obviously on a slide-by-slide, and hopefully I will cover all the questions that have been raised. On the slide 3, about what we propose, the security measures that are required, and as we propose, we certainly, as Honorable Member Mayor has indicated, we would like a dedicated branch of Railway Police to have the capacity that we propose to be able to investigate, to prevent measures, and to be able to dedicate itself to the sketch that we've seen. Certainly, that incident and the number of incidents indicates the extent of vandalism and extent of issues that we deal with on the ground. We're certainly not distancing ourselves from our responsibility as PRASA to deal with safety measures. Part of our requirement and part of the safety permit is that we have obviously to protect the commuters and our assets. And therefore that responsibility, we obviously mindful of it, and it's fairly within our control. But the scourge of vandalism and theft that we've seen obviously requires a more concerted effort, starting from a branch of a component of the police that will be dedicated to that responsibility. Honorable Member Mabena wanted to find out what steps do we take in terms of cooperation and obviously liaising with other operators in terms of safety. We believe certainly that we are cooperating. As part of our function and as part of our key responsibilities as an operator, as a responsible operator. But what we're seeking that the regulator should be empowered to do, and certainly not forcing it, other than empowering the regulator to do, is that it should then force cooperation. So as part of our application process, we do provide a safety and security plan as to how we intend to ensure that safety within operations. But we believe that there's an interface regime that the regulator has and has authority to regulate. So we believe that there can be an interface with set security standards across some of the infrastructure that we have. So typical example, what we're thinking ahead is that, so typical example where we delineate as a critical infrastructure, a substation, and the substation that are about 2 operators, that we then, the regulator would obviously want, as part of our submission, to know how are we going to obviously allocate the resource to make sure that those critical infrastructure that we can control and within the realm of our control, how are we going to make sure that we do as part of our presentation, so that it doesn't become a coordinated approach in terms of us as operators. If you consider, the current operations, we obviously are backing each other, certainly from Transnet and us, but certainly our connectivity to how trade. We do are connected. So where we interface, where we believe that those resources could be called. So we empowered the regulator to call all the operators so that they then have, if you like, a joint a forum where the regulator can take a lead, ensuring that the safety standards that are put out by the operator within a certain operating space. I'll go through it and then you will obviously pick up the next. Okay. So question is, why do we seek to have a sun standard as a medium and as a sole medium for as a common safety measure? What we're saying is certainly sun standard has been from the date when the regulator in 2000 came on board. Sun standard is a standard that has been created in collaboration with the rail operators. So we want obviously the rail operators as part of the making up of those. So that element of self-regulation is then brought into the fore. But as the sole measure, when I say sole measure, it doesn't mean it will not be updated to take into account international standards and international requirements, because that will be the sole measure. It is easy to improve, and we know what the difficulties are as an operator and as a regulator. So that standard will be adaptable to new measures that are required. And safety management system, we found that in our application, certainly in the last at least 3 years, that the regulator will introduce other measures that are outside the sun standard, and it becomes a difficulty as to which one regulates the industry, is that the sun standard or the new measure, and necessarily the regulator will then obviously invoke the application of the sun standard when we said it may be that for commonality and for purposes of legality and operating from the same page, that we propose that the sun standard be the sole measure. So if there are any improvements that needs to be made from the safety management system, they would obviously be incorporated into a sun standard, which is a South African standard that has been developed by by operators within South Africa. Obviously, it is run certainly by the regulator. It is done within the auspices of South African Bureau of Standards. So it will be mindful, obviously, of other safety security standards that some the SABS would want to bring onto the fore. So that's why we're saying it's an ideal way of ensuring that the safety management system is aligned with certainly with national standards as well as international changes that may happen. Clearly, from either being an ISO standards that are required to be taken into account, or any engineering standards that may come from ISO. SABS, my apologies, stands in a good step to be able to incorporate those key changes. Safety management system and the permitting system, why do we require timelines? We have had experience where in our application process, so the current requirement is that an application must be made 90 days before the expiry of the existing one. So what we found, and certainly for the reason that Honorable Member Mabena has indicated, there may be issues that you want to discuss with the regulator. And it may be that at the end of the 90 days, they have not made a determination as to whether we are, as an operator, entitled to a permit or not. That is an operational matter, but we don't want to be, especially for current operators, and we preface that discussion by saying there must be a distinction between a new applicant as well as a current operator. As a current operator, there's an expectation from a mandate perspective that we carry on doing what we're supposed to do, unless obviously the regulator believes that we're not entitled of a permit. But the period of permitting and processing permitting and the end of 90 days do not necessarily dovetail, which then requires, and we have incidents where the regulator would extend the permit. In terms of the current legislation, they can't do it. The bill doesn't propose an extension of an expired permit because it's given for a period of time. So what we're suggesting is the solution is that instead of creating that difficulty from a regulator, and actually certainly from a certainty perspective from an operator, that if an operator does not come about on a particular date, let it be deemed extension. The extension will then obviously be subject to conditionality that the regulator can put in place. That's one option. A further alternative would be that especially for current operators, that the regulator would then be forced to make a decision within a certain period before the expiry of the 90 days. So there's at least a time period that we know in case we need to, to take whatever action that we need to do, i.e., appeal a decision by a regulator, or take the necessary legal action that we know within 15 days before the expiry of the permit what action we need to do, we need to take to be able to keep that safety permit alive or not. So the optionality is there. It's not that we're forcing the regulator to make up its mind. We're saying it creates certainty for us, because if we do not, firstly, that if we carry on an operation, clearly because there's a vacuum in terms of whether the regulator has pronounced itself as to whether we're going to get a safety permit or not, and there's unclear, lack of clarity from that, we may face the risk that there's criminal liability on the operator, but or alternatively, we may lose the insurance cover that we have. So we want certainty, and that certainty, to prevail, especially in areas where the regulator believes that we're not meeting any of the safety conditions that they have in place. And we require extension of the permit by law. I'm hoping I've answered the other questions about that honorable member may have raised, whether the fine and the fine regime is it effective or not as a measure to ensure compliance. Well, the fine is available to regulate, certainly, because that is the basis for at least it exhibits non-compliance on the part of the regulator. That is an effective system because obviously it takes away money from us, and certainly it takes penalty. But it's not only the fine that's the end of the message, because the regulator can prohibit an operator from operating in terms of its current enforcement measures. So we believe a fine, a penalty system is a fair measure and it's something that a regulator should have. But we do not believe that it's without option, certainly. And on the issue that was raised, whether should a failure to pay a permit or a levy be visited by suspension, we believe that the two are out of kilter. The regulator will always have a means to recover any amount that is owed to us. And generally, we do pay our penalty and levy, and certainly, but we believe that a suspension as an enforcement or as a sanction should be left to where an operator exhibits a lack of compliance with safety measures and not necessarily be used as a recovery of cash by the regulator. Well, the other issue that under 8 that the honourable member have indicated is whether are we intending that managers should not be held criminally liable. That's not the point that we're making. We believe that the issues that we raise is that one is that if a person is going to be criminally liable, it must be a measure that shows that the person, the accused, and I call it the accused in this case, has intentionally and willfully failed to do what they were supposed to do. What the bill proposes is that if you fail to report, and without question as to what's the basis for failing to report, that is in itself is a criminal liability. Because it's not necessarily, it may not necessarily be true. We understand if you fail to report, that is under the current scheme of the legislation, that it can be penalized. So if you fail to pay, you can be penalized by the regulator. That system will carry on. We accept that, but we do not, in any event, in any manner, propose that no one must be held criminally liable. But we're saying if criminal liability and imprisonment is to visit an offense, it must be based on it must be based on an intention and willful intention on the part that they purposely wanted to avoid compliance with a particular legislation. The honourable member raised a question about whether the definition or the inclusion of the term of the phrase all steps.
Hello.
Yeah.
I was just saying my request is that let's not expand on the explanation. We are going to get into the process of dealing with this issue as we move on, highlight the responses so that members are clear in terms of what they had asked. Please, thank you.
Thank you, Chair, and thanks for the direction. or the measure whether all steps is ideal in section 15. Now we believe that the problem with interpretation is that, as indicated, members of the board are required to obviously to exercise strategic input into the process. When they're asked and required to take all steps, they effectively descending in an era in an arena which is dedicated for management by virtue of delegation. But we then say, because board they're crafted for their skills and their mix of skills and expertise, it may be difficult to expect of every person who brings different skills into a board to be expected to bring to take all steps to avoid criminal liability that attaches to the employees who are dedicated and given responsibility. And by virtue of experience and their selection and for their skills, they are probably the best people to be employed for that particular purpose. To ask of every member and every single director, it might be seen to be an overstepping of the requirements. On the King 4 requirements, we just certainly indicating that the King 4 obviously is an accepted corporate governance tool within South Africa. And we say if the board is expected, and it is expected in terms of the King 4, to lead as expected under King 4, we should then not divorce the responsibility expected under King 4 and to be projected differently under the bill. Hence, our requirement that the tenants that have been created under King 4, and certainly insofar as liability and criminal liability of a director, must then be in accord certainly with the King 4 as well as the business judgment rule, which requires that members must apply themselves, they must act within their financial responsibilities. So we believe that is a good measure for a board which may not be operational, well, which ordinarily is not operational and delegated the responsibility to management on the operational level. I think I may have covered all the issues, but I'll let my colleagues please.
The issue of failure to pay fees and levies not to result in suspension. We've covered. Okay.
Yeah, I'm hoping we've covered all the questions and the issues. I'm just going around the table to see whether I may have missed something. Yeah, I believe that we've covered all the issues that were raised, unless there are further questions, which we happy to engage with the committee on.
Thank you, sir. Thank you very much for covering the questions. We'll still engage with you. Prasa, could you kindly look at the issue that was raised by Honorable Mabena, and please revert back to the committee about it. Otherwise, we want to thank you.
Thank you, Chair. We know that there is questions, and we'll certainly revert to the portfolio committee on it.
Thank you. Thank you, sir. You are released and liberated.
Thank you, Chair.
Honorable members, thank you very much. Honorable members, we have 30 minutes. We can take 30 minutes and come back and try and wrap up. If we take the 30 minutes, we will have to come back at 20 to 1. Or do you want us to extend it to 1:15 for lunch? Babu Mabena, ngiyakubona ukuthi ufuna ukuthetha baba.
Yes.
Uthini baba?
Yes, ngifuna ukuthetha because the chairperson invited me to tether, so I have to comply.
Yes.
Chair, just to know that at 1:30, I'm going to have to leave the meeting because I have a 2 o'clock meeting and then I have 30 minutes traveling time. So if the secretariat could note that. Otherwise, your proposal, I am not hostile to.
Thank you very much. Babu Mapena. Honorable members, can we agree? Can we come back 1:45?
1:45 is fine, Chair.
Thank you very much. You are released 1:45. We are here so that we bid good luck to those who will be leaving at 2. Thank you very much. The meeting is adjourned.
Before you adjourn, Honorable
Yeah.
Christina is also leaving at 2.
That is why I'm saying so that we bid farewell to those that are leaving and good luck.
Thank you.
Thank you.
Recording stopped. Yes, we are. As soon as you want me to go ahead, I'm ready to go ahead, Chairperson.
Okay, thank you very much. Let me just start my car and I will then ensure that I hand over to you. Honorable members, I thought I should indicate that we are back, and I'm sure that you had a light lunch so that we can deal with the work ahead of us and finish. Comrade Matthew, we will be giving you 40 minutes. It means 10 to 1 up until 1:30. Then you can bring the reins back to us. Otherwise, we want to appreciate the fact that you have set aside time as always to talk to us. Let me take this moment and hand over the reins officially to you. Over to you, Comrade Matthew.
Okay. Good afternoon, Honorable Chairperson. Good afternoon, members. Thanks for having us. Let me just cut straight to it and put my presentation online. But yes, no, thanks, Chair, for giving us space as COSATU to raise our views. My name is Matthew Parks from COSATU. So I'll just do our presentation quickly. And I think for us, Chair, as organized labor, the railway safety is quite a critical bill. So we're looking forward to its passage through Parliament. So I think, Chair, look, we want to say as COSATU, we welcome this railway safety bill. We think it's long overdue. We support many of its provisions, which we think are quite progressive, and we're looking forward to it being passed by Parliament. But having said that, Chair, that we are worried about some of the clauses in the bill, which we think are either silent or are vague, or in fact are worrying on some critical issues. And some of these issues, Chair, we think are the failure to provide for and effect the exclusion of the representation of workers on the Railway Safety Board. We think there's a mistake not to set fixed requirements for Railway Safety Board meetings during the course of a year. We're also worried about some of the provisions which we think actually will undermine collective bargaining on critical matters of conditions of service, about labor matters. We support, the consultative forums provided for, but it's a bit concerned, but they're a bit vague about the composition. We welcome the powers given to inspectors to do inspections, but we fear that limited to working hours in most circumstances will be hindering the inspectors. Again, we're not comfortable with the issue of denying employees the right to appeal to the CEO of the board appeals committee. But I think also critically, given the state of our railway lines, both passenger and freight, it's quite worrying that the bill is silent about who exactly is responsible for ensuring the safety of commuters and pedestrians at the railway crossings and the rail lines. And often at times when you engage with government colleagues, there's just a shifting of bucks between them. There's also a silence, we fear, Chair, that given the current context of debilitating levels of copper theft, arson, vandalism, and the kind of general levels of criminality we see crippling transit and metro rail, we feel the bill should have gone a bit further to deal with those crises. But I think, Chair, look, as COSATU, we support the bill in its objectives, but we are worried about this kind of silence on these critical parts. We fear that if they're not addressed, it will really be a missed opportunity to try to resolve fundamental weaknesses in the bill and the real cancers threatening the very survival of transit and metro rail, which are amongst the most important national assets, economic assets. And this is something really that workers and the economy cannot afford. So we do hope that Parliament will exercise its constitutional powers to amend and strengthen what is otherwise a very progressive and a very critical bill. So, Chair, our support for the bill, we support the bill as a whole. We do look forward to being passed by Parliament and to be implemented by government. We just think there's some areas we need to strengthen to achieve its progressive objectives, which are correct objectives, and to really deal with the crisis of railway safety affecting railway workers, commuters, and the economy. Chair, we support the extensive mandate and powers given to the regulator and the inspectors by the bill, in particular to withdraw permits, to shut down operations, and the inspection search and seizure powers. These are really quite critical to ensuring the regulator and the inspectors are capacitated to fulfill their mandates. Chair, on terms of clause 10, which is the composition of the board, this is one of the areas of concern. So we're quite disappointed the bill doesn't provide for any representation of organized labor on the board. This is despite COSATU and other unions organizing railway workers having raises with the Department of Transport previously during consultations on the bill. This is despite an assurance given by the Minister of Transport, Honorable Mbalula, that in fact this would be addressed. And our motivation, Chair, is that workers run the railways, obviously. They have extensive experience in railway safety matters. They already bring on board invaluable knowledge and expertise, but also I think politically it helped to ensure the inclusive buy-in collectively of workers tasked with ensuring the safe running of our railway network. Chair, so our proposal that, look, organized labor should be a full representation. It should be in the bill, shouldn't be just simply at the discretion of a minister. There's also an existing clause speaking to expertise in labor matters, which is there, but Chair, we feel that if you leave it at that, it can be interpreted as simply as having a person who is an HR manager or labor lawyers. We've seen previously in the Broadcasting Act where the board said they should have people with expertise in labor, and what has been done by Parliament and by government then in those instances is simply to appoint an HR person or labor lawyer, not a representative of workers on the ground, which is a very different concept. Chair, we think that there's a need to have 2 labor reps, which helps to ensure the diversity of organized labor that's in the passenger rail and also the freight rail, because they represent quite distinct conditions. We think it's also critical that when you had the provision for organized labor representatives, that it should be organized labor which selects these representatives and not just simply a minister appointing them, because that can also be open to abuse. So proposal for clause 10, Chair, is simply a new subclause, 10(1)(b), be inserted, providing for not less than 2 representatives of organized labor reflective of passenger and freight rail to be selected by organized labor and included in the board. We think there's sufficient legal precedence in other boards to do so. Then, Chair, in terms of the disqualification from appointment as a board member, so clause 15, D1 and 2, it prohibits the inclusion of any person in the employment of government, be it in the public service or any other organ of state. So in effect, that would prohibit any worker employed by Transnet or Metro Rail from serving on the board. And this would in effect deny workers effective representation on the board and representation that would include invaluable experience and expertise. Yet, Chair, there is exceptions provided for this exclusion for government representatives. So a representative from the Department of Transport, for example, would be allowed to be deployed to the board. So we think that provision should be extended to allow the same conditions for organized labor representatives. So proposal there, Chair, for this clause is just simply to insert a subclause 15D2, or to extend it rather, to also exclude organized labor representatives from that prohibition. We think that could simply be a quick and simple way to address it. Chair, then on the meetings of the board under clause 17, it's silent about the minimum requirement of board meetings to take place annually. We think this is contrary to the norm in many of our legislation, which stipulates the board should meet at least quarterly. We think the danger of not having a minimum number of required meetings is that the board may simply choose to meet once a year. And this, we think, would undermine its ability to function, to fulfill its legal mandate. And the minister would have very little recourse, even board members have little recourse, because the bill will be silent, so you couldn't force the board to do otherwise. Again, Chair, this is, in the context of Metro Rail and Transnet experiencing real crises of railway safety, resulting from copper theft, vandalism, arson, criminality on a daily basis. So we think at the very least, the bill should be amended to require the board to meet at least quarterly. We think that would be a fair compromise. Chair, so our proposal simply would be to insert a new 17.2 to require the board to meet at least quarterly. Chair, then in terms of the regulator, the staff of the regulator, clause 23, 2A, and then also 3 and 4. So these determine the conditions of appointment of the staff members of the regulator. The minister, with the concurrence of the finance minister, must approve the annual increases for the staff members. The board may also, with approval of the minister and consultation of the finance minister, establish, manage and administer any pension fund or provident fund or medical scheme for the staff. And such a fund or scheme may be managed or administered by a person approved by the board. So that's in the bill. But in fact, Chair, this bill is now silent on the constitutional right to collective bargaining for workers and for them to be engaged on the conditions of service. It just simply says the ministers decide. So we fear, Chair, this undermines collective bargaining and occurs against a real backdrop of government increasingly seeking to collapse or to ignore collective bargaining, the voice of workers. It undermines the traditions of collective bargaining and engaging with workers, which does take place at Transnet, at Metro Rail, and the regulator. So, Chair, also we want to say it doesn't make much sense for the state or for the state or for workers, for the regulator to establish its own provident fund or its own medical aid when we have the government employee pension fund or we have the government employee medical scheme. They exist, and simply all state employees should be part of them. We should not be fragmenting these resources. You'll get better benefits, better security and sustainability of the funds as well if you combine. Chair's proposal in this regard is just for subclauses 24, 2A and 3 be amended to include in consultation with organized labor and subject to any collective agreements. So that's the issue of the conditions of service. And then for subclause 24.4 be amended for employees of the regulator to be included under the Public Service Collective Bargaining Council regulations or decisions, the GPF and GEMS. And again, we've done similarly, Chairperson, before with the Border Management Authority. So there is ample legal precedence to do so. Chair, just on the consultative forum, clause 38. So this clause provides for the establishment of this consultative forum. It doesn't give any or provide any criteria as to who should be included in such a forum. We think this actually could inadvertently undermine the very progressive intentions of this clause. So we do think it needs to indicate some criteria, for example, organized labor, commuters, businesses, civil society or communities, or relevant government institutions. So proposal here, Chair, would be to amend subclause 38.4 to specify that such fora should, depending on the circumstances and objective of the fora, include representation from organized labor, commuters, businesses, civil society, communities, and relevant government departments. On the enforcement inspection is subclause 44.6, Chair. So this is a bit of a concerning area if we want to really empower the inspectors. So it limits enforcement inspections to between 8 a.m. and 5 p.m. during workdays, unless authorized by a judge or magistrate. So that's a significant limitation and a significant amount of bureaucracy to go through. We think it's really an unnecessary infringement upon the powers of the inspectors. Passenger and freight rail are not limited to operating between 8 a.m. and 5 p.m. Monday to Friday. And neither are matters affecting railway safety limited to office hours. So for us, it makes no sense. We think it's an unnecessary limitation on the inspector's ability to fulfill their duties. It may actually aid unintentionally those at fault and provide them advance time to dispose of incriminating evidence. So we think, Chair, simply that the reference to office hours and days should simply be deleted from the subclause. So our proposal for 44.6, Chair, is to, simply, delete the reference to the hours and the days, and to empower enforcement inspections to take place at any time or date as the need arises. Then, Chair, just in terms of the appeal provisions, it's getting towards the end. So the appeals to the CEO in subclause 54.1, it denies employees of the regulator the right to appeal to the CEO. We think this is unconstitutional infringement upon the right of such workers. The bill doesn't give other recourse alternatives for these workers. So we think this exclusion should just simply be deleted. And so proposal for subclause 54.1 is that it should be amended to delete the reference to employees in the list of those denied the right to appeal to the CEO. In a similar spirit, Honourable Chair, on the appeal to board appeals committee subclause 55.1, it also denies in the same vein employees of the regulator the right to appeal to the board appeals committee. I think this again an unconstitutional infringement upon their rights. And again, the bill doesn't give alternative recourse to these workers, and we think it should simply be deleted. So our proposal is for subclause 55.1 to be amended to delete the reference to employees in the list of those denied the right to appeal to the board's appeal committee. Then the last two areas is about the kind of real existential crisis we're facing, so that we feel the bill is silent about the responsibility for who's responsible for the safety of pedestrians and commuters on the rail line crossings, and also the railway lines as well. There's not much clarity on it, and when you, again, it might sound like an obvious thing, but when you engage with government, be it national, provincial, be it Metro Rail, Transnet, be it municipalities, there's a continuous shifting of bucks between them. We've all seen, and we've seen the horrific accidents that have occurred, even in places like Cape Town, as a consequence that many rail crossings, urban and rural, which really lack sufficient or any safety provisions, some are completely unsecured, have no fencing around them. So if you go to the line at Langa, between Langa and Pinelands, the fencing has been removed. People can just walk across. And we've seen the consequences that there are deaths of pedestrians. We've seen the horrific accidents where taxis with school children jumped the railway crossings and then dozens were killed. And we've seen often that you just simply see a kicking of responsibility between Transnet, Metro Rail, local government and provincial government. So we do need to really clarify for everybody who's responsible for which part, etc. But a consequence, Honourable Chairs, is that there's a deterioration in safety and security and an unnecessary loss of life. So I propose to Chair is that there should be a new clause inserted to indicate who's responsible for securing crossings and lines, what are the different responsibilities of Transit and Metro Rail, province of local government. Again, this is an obvious thing, but the fact is there's a real crisis as a consequence. The last kind of issues, Honourable Chair, is that so we're witnessing rampant corruption, criminality, copper theft, arson, vandalism, across our railway lines. We've seen millions of rands worth of copper cable stolen monthly from Transit and Metro Rail. The consequence to the economy just last year alone was about 50 billion rand. From Transit itself and Metro Rail to also the downstream economies like mining, manufacturing, etc., to the state and so forth. We've seen continuous delays in service and at times death because of railway accidents. We have witnessed the death of commuters in Pretoria a few years ago because the signals couldn't work because of the theft of cables. We've witnessed more than 100 Metro Rail carriages being destroyed in arson attacks, again, costing the fiscus millions of rands of service delays, but we've seen very, very few arrests and convictions. Chair, so we're witnessing the kind of systematic destruction of Metro Rail Transit by these criminal syndicates. It's caused many commuters and businesses to abandon Metro Rail Transit, also having a burden upon the economy and upon commuters. It causes them real hardship. And again, it costs Metro Rail Transit billions of lost revenue, but we're seeing very, very few prosecutions. We've witnessed billions being spent on, to be honest, very inefficient security for Metro Rail Transit with not much impact. Often there's been serious allegations that some of these security companies' contracts have been mired in corruption. At times, allegations have been made that some of them might themselves be involved in acts of criminality, of cable theft, of arson, etc. We had been hopeful when the Minister of Police had made a commitment publicly to re-establish a dedicated railway policing unit, but this hasn't happened as of yet. So Chair, proposal on this front really, as I conclude, is that we need to re-establish the SAP's dedicated railway policing unit, but in the meantime, can we also deploy the Defence Force to assist SAPs to re-establish secure and control of the railway lines, in particular commuter lines. As a conclusion, Comrade Chair, we support the passage of this bill. It's a progressive and it's a long overdue bill. We think it's going to go significantly towards empowering the regulator and the inspectors to fulfill the obligations. We are, though, concerned with regards to some of the above-mentioned issues we've highlighted and gaps in the bill. We have raised this previously as COSATU with government without much success. So we hope as COSATU, the Portfolio Committee will take our proposals into consideration. We hope members would agree with them and see how can we address them in the bill. We don't think that anybody should be opposing them. We think the department should agree to them because it really is about strengthening a very progressive bill and getting it right now, not delaying any further. We think these will really help to ensure the bill is sufficiently strengthened and it can meet its progressive objectives. So let me stop there, Comrade Chair, and thanks members for giving us space as COSATU to indicate our support and our proposals to strengthen the bill. And hope I didn't take too long. Thanks very much, Honourable Chairperson, members.
Thank you very much, Mr. Matthew from COSATU. Let me see if we have any clarity-seeking question from honorable members. Honorable Chris Hunsinger. Who else wants to raise an issue? Okay. Babuketa Mobala. Those are the two hands I've noticed. Thank you. In the order of they are raising, Honorable Hunsinger.
Thank you, Chairperson, and thank you very much for the submission, Mr. Parks. In particular, thank you for emphasizing the necessity of also considering inclusion of a higher degree of safety around railway crossings. Could I ask you what your further ideas would be from a railway safety regulator point of view, how that particular area of rail and commuter or passenger vehicle and pedestrian crossing can be enhanced? What are your particular ideas around this? And then how the railway safety regulator can enhance its effort from that side in a legislative manner. Thank you, Chair.
Thank you, Mhlekazi. Baba Uketa Amabala Umondis.
Thank you, Honorable Chairperson, and thank you to the federations for their presentation. Only one question, the Chairperson, that I need to get the understanding from COSATU about the issue of vandalism in our railways, according to their thinking and to their operation. How many security can be implemented in this area of businesses? And the other one, Chairperson, is the issue of they are not included in the board. How many members do they want to be included in their board? In the board. Thank you very much, Honorable Chairperson.
Thank you very much, Baba Uketa Umabala Ustole. As you lower your hand, say, Comrade Matthew, back to you, sir.
Okay, no, thanks very much, Honorable Chair. And yeah, thanks to the members.
There are two hands.
There is, just hold on, Honorable Matthew. There is something that I need to deal with in this committee. It's a request of saying people must raise their hands. And once I've closed, I've closed. I think I really want to request that particular heeding of the call. When I've said hands, I've noted two hands and I've called those hands. Let me take Honorable Mapena. I hope that message is clear from honorable members.
Chairperson, I raised my hand.
I am saying I have noted that, and I want members to help me on that matter. I really want you to help me. Honorable Ramato, I can see your hand is raised up now. I will recognize you. Thank you. Honorable Mabena.
No, thank you very much, Chair. I think we have always aligned ourselves with that directive from you, but I think perhaps maybe the technology and the bandwidth and the slowness of maybe the response system in terms of when we raise hands, maybe that should also be taken into account. You know, I think maybe this is also a rallying call that we should do away with virtual meetings. We should come back to Parliament, like some of us who are here. That we should have, you know, face-to-face meetings. I think next door they're having a portfolio committee meeting into the fitness of the public protector, and it's an in-person meeting. So if they can, maybe we can also do it, because in that way, when I raise my hand, I know that my chairperson's eyesight is very clear and very powerful, that he can be able to recognize me very quickly. You know, so Chair, my contention really is just one, perhaps was touched by my colleague, but I don't know, Mr. Parks, you seem to have a problem with, you want to insert a new clause in the bill, especially in the composition of boards, clause 10. And you are saying that you want organized labor to be included, to be part of a board that runs a regulator. I don't know, but because remember, this is not a bargaining council. This is a board which runs a regulator, which looks into one of the sectors. Now, what would be the contribution of the said organized labor, and what would be the criterion that is used? Because if you would remember, the composition of boards, which is strictly, you know, adhered to in terms of legislation when this recruitment for board members is done, there is an elaborate process where you would want experts in the field, people that have had experience in terms of running these entities or in the related fields, where they would come and that have relevant executive experience, that they can come and contribute into those boards. But now, if you want organized labor, and you say that you also have a stipulation that you want to have 2 people that would be representative of that board. And remember, these board members must make executive decisions which might in turn affect your workforce. So then what then happens? Because, you know, also board members, there are also there are subcommittees within these boards. What would then be the contribution of organized labor in such a board? Because essentially then it means you have organized labor, which is, or unions which are now running boards in this space. I think it's a serious breach, and it's also a conflict of interest, because I mean, this is in essence, like, we're not in a bargaining council type of situation, but these are actual board members which have to run this entity. What would be the contribution of such? And to be bold to say that you want like a new clause, 10.1b to be inserted in that, I honestly don't think it's assisting this committee, but maybe you can elaborate. But I don't believe this should be the route that we're taking, because we're opening ourselves up for one, possible litigation, but also, I mean, like, it just doesn't make any perhaps team. It doesn't augur well for the way an independent board needs to be run, whereas we have organized labor, which is organized labor is there and it's organized on the side. Now, what happens when a board has to take a decision which is in conflict with organized labor? Therefore, you're going to have those people voting in a certain way. No, but perhaps you can assist us there.
Thank you, Honorable Mabena. Honorable Ramadwa. Honorable Ramadwa, are you here?
Thank you, Chairperson. I'm covered. Thank you.
Thank you. Let's go back to Mr. Matthews. Comrades.
Sure. Okay,
Comrade
yeah, I can go.
Banks.
Sure, no, thanks very much, Honorable Chair. And yeah, thanks to members of the questions. So I think it was basically 3 sets of questions from members. I think to Honorable Hunsinger about railway crossings, we shouldn't, Honorable Chair, even be having to have this conversation. It should simply be obvious that railway crossings are always going to be a point of risk. We need to have kind of very tight controls upon them. Legislation should be very clear, but who's responsible for them, etc. So this shouldn't be it's not a complicated thing. But surprisingly, we've made it complicated because I think if you go to any of our railway crossings, whether it's in Cape Town or suburban areas, where you can find the guards, the lights, etc., have long stopped working. More of you, if you can even go to some parts of Cape Town and Gauteng and other cities, where there's actually no security at all at the railway crossings. You can go to many of the railway lines. There's no security along the fencing, etc. Some of it, yes, because of vandalism, because of informal areas over the past 2 years expanding. But in most instances, really, it's just simply the fault of the state, be it Metro Rail, be it Transnet, etc. But when we engage, Chair, with Metro Rail, Department of Transport, with Transnet, with provincial local government, everybody just simply sees to say, well, it's the other person's responsibility. That's fine. But I think here, Chair, we have a foundation legislation, which is the Railway Safety Bill, which is exactly that, about providing railway safety. Ensuring minimum standards, norms and standards for railway crossings should be a really critical one. So I think for us, Chair, it's one about establishing very clearly for everybody to know, including the public, who often wouldn't know where to report issues of railway safety. It's also about assisting the police officers who also wouldn't know where to handle such issues, who to engage with from the department or from government or the entities. So I think one about indicating who is responsible. I think the second one is to provide a framework for determining and publishing minimum norms and standards, like you do with education, for example, for schools. And then obviously those can be provided for in the regulations, but there should be at least a clause in the bill who says this is the people who are responsible. The minister will determine with the relevant entities minimum norms and standards, will publish them in regulations, etc. But I think, Chair, our fear is that right now the bill is silent on it, and we can see the consequence. I think we all saw the issue of the taxi driver about 5 years ago in Cape Town, and I think it was in Klapmut near Stellenbosch, if I'm right, who jumped at the railway crossing, and as a consequence, many children lost their lives unnecessarily. And sure, one could have blamed the individual taxi driver who was later convicted in that instance, but at the same time, it would have been impossible for that taxi driver to have jumped the line if there was a security of the railway crossing. So I think that's the one critical thing, Chair, because otherwise it will just simply defy logic. If we keep silent on it, we don't have any mechanism legally, and yet we continue to allow this situation in reality to happen. I think, Chair, to the next question about the issue of vandalism, I think a proposal right now, we're in a real crisis, and I think there is some good efforts by government in discussion with Labour and business and NEDLAC and so forth. I think there was a briefing this morning by the Minister of DTIC to Parliament as well about the cable theft. So I think there is some good interventions there about a temporary ban on the export of scrap steel and copper, the kind of ideas around regulating the scrap dealers. But I think those will take some time. In the meantime, Chair, we should be deploying the Defence Force to immediately secure our railway line network before it's destroyed. We're witnessing literally about 100 or 200 kilometers of railway cable theft occurring every month. It is a huge pandemic, so to speak. But of course, we think the longer-term solution is to revive the SAPS railway unit. The Minister of Police had talked previously in the Portfolio Committee on Police about 5 or 6 years ago about insourcing security functions at Metro Rail and Transnet, because the amount of money they spend there is in the billions, and that could really help to ensure they have a dedicated SAPS railway unit. But something needs to be done, Chair. The status quo is a recipe for the total destruction of our railway network. Then, Chair, just to the questions around the composition of the board, I think there's two members, including Honorable Mabena. Perhaps, Chair, it's an ideological point of difference between COSATU and the DA, and that's the DA's right to be opposed to organized labor. including organized labor sitting on boards, but it's in the norm of South African legal practice. Countless boards in South African governance have worker representation there. And we ask why. So who do we think runs railway lines? Who has the greatest amount of expertise in railway safety? It's our train drivers, it's our conductors, it's our security guards, it's the collectors of tickets, etc. It's the staff, it's the technicians, the electricians, the repairmen. Those are the guys who make sure that our railway lines exist in the first place, who have built it. Those are the guys who have the most granular expertise, as opposed to getting some lawyer who may have nothing to do with the railway safety. So I think that's the one question. So they will bring significant expertise to it. But I think, Chair, also we want to ensure maximum buy-in of whatever policies, campaigns, decisions the railway safety conductor, regulator makes. We want to make sure all of the staff, and there's a significant amount of staff you have in Transit and Metro Rail. Transit, if I'm right, is about 56,000. Metro is a bit smaller, but still a very large employer. So you really want to ensure maximum buy-in. One of the ways to do that is for organized labor, for workers to feel they're part of the process for developing railway safety plans and policies, directives, to help ensure the communication flows to them, to help ensure that whatever ideas or concerns they have are raised, are ventilated, are addressed and resolved. So, Chair, the Honourable Member Beno, when he raises the point, it says it seems to be that I'm raising a bit of a strange concept. Sure. Well, we're not raising it for the first time, and there's ample international precedents. If you look at the examples of Germany, Sweden, of Norway, of Denmark, of Finland, look at the examples of Japan, both in the public and private sector. If you look at VW, how it's run in Germany, there's worker representation there, where workers choose the representatives. Same thing with Toyota. There's Amazon international precedents. It's called the co-determination model. There, in fact, is legislation being developed by DTIC to provide for company representation on not just government boards, but even listed company boards. And we think, Chair, people have a contribution to make. And we would assume when the DA goes to vote to workers to ask for the vote, they will also respect that contribution to make and not just ask for the vote on election day. But these workers have got real expertise. They can help to ensure the success of this railway regulator. Railway workers have a vested interest in an effective regulator because they are the ones who die when trains collide. Commuters who are workers in a large depend upon an effective institution. Again, they need to hear their voice being heard. So, Chair, we're not thinking that this is the problem. I think this is actually going to help to ensure success. Our motivation for saying 2 representatives is because the railway sector regulator have to deal with 2 distinct areas. They have to deal with freight rail, covered by Transnet. They have to deal with passenger rail, covered by Metro Rail. So different issues. Transporting of goods has different conditions. Transporting of passengers has different requirements. So I think first it's critical to have both included. We also think, Chair, it's critical, given the experience of corruption, etc., that is workers who choose through the collective bargaining forums, in this instance, their representatives to serve on the board. Or the minister can appoint, but it should be at least an element of workers nominating and selecting their representatives. Chair, we don't think there's a conflict of interest. And if there is conflict of interest, you always have provisions on boards for people to be excluded. So, for example, if they're discussing issues which are actually collective bargaining, not railway safety, you can provide for the exclusion of those persons. That can be done all the time. That's a normal practice of all boards. When people have conflicts of interest, they are recused. But, Chair, we don't think it makes sense to simply say to divorce workers from railway safety. They have a critical role to play. They're affected by it. We think their voice would add significant value to it. And again, if you look at most of our boards, it provides for it. We think when the drafters are drafting the bill and they made reference to labor, that's what they intended to do so. But we think it needs to be made clear that it's organized labor representation and not simply somebody with expertise in labor law or somebody who's been an HR manager, etc. So, Chair, we had hoped that this would have been already included in the bill. The Minister of Transport had made such a commitment before. He's actually appointed representatives from UNTU, which is one of the unions organizing railway workers, to the board. We think that's a positive thing, but we need to just simply put it in law, because if you don't put something in law, then a future minister on the road will not feel obliged by it, may not even know about it, and hence you would not be able to hold them accountable to it. Chair, I think maybe the last thing on this point is that the 5th Parliament had drafted the PIC Amendment Act, is now an Act of Parliament. Its original author was a DA member of Parliament, David Mania, and he correctly provided for and we had agreed to that proposal for organized labor representation on the PIC board. That is a response to a proposal we had made as COSATU. So it's unfortunate the DA is now kind of going back from that kind of progressive stance previously, but we would hope that other members of parliament would see the value of having workers serving on boards, that the voices do have some value, and they're not just merely the salary recipients of the employer. But hopefully I've answered the question, Honorable Chair, and apologies if I missed out anything. Thanks very much.
Thanks very much, Comrade Sparks. That was COSATU. We will, during our interaction, consider what your submission is saying, like all other submissions. We thank you for making time to come and talk to us. Thank you very much, sir.
Thanks, Comrade Chair. Thanks very much, members.
Thank you. You are released from the meeting. Thank you very much. Members, we were supposed to take, okay, there's a hand here. Oh, okay. Comrade Parks, can you go with your hand, please? Thank you very much. We're supposed to take the UNTU. UNTU is the United National Transport Union. Yeah. I'm told that they are not here because they don't have somebody to present orally, but their presentation is already with us. So we can be able to deal with it at the point when we are considering all the presentations. So we have basically exhausted all the presentation that we needed to do. There is a request before I bring this meeting to its conclusion by, what is the name of the company again, Valerie, that requests to present tomorrow orally?
Chair, that is Bombella Operating Company.
Bombella Operating Company is requesting to present orally tomorrow, and their reasoning is that they thought that what they wanted to present would already been covered by the previous presenter. Is it Gautrain, Valerie?
Yes, Chair, and they also said they want to raise critical issues in terms of the bill.
So I thought I should raise this matter because we normally at this stage don't close people outside. Honorable members, can we consider, can we agree to give them an opportunity to present tomorrow orally?
Chairperson, my hand is up, Chairperson.
Honorable MacDonald.
Thank you, Chairperson. Chairperson, I think let's give them the opportunity to present. I think it will be good. I don't know if it will, how much it will impact our scheduling, but I do think that anybody that's got anything to say about this bill will only make the bill a better bill, so that we, at the end of the day, shape the legislation so that it suits all South Africans. Thank you, Chairperson.
Thank you very much. Any opposing view? Going once, twice, thrice. Thank you very
Mangat.
Baba, aha, ngiyasibona ke isandla. Isho-ke mfowethu.
Bengifuna ukuchecka la Mangat ukuthi imbombela ehlukene nembombela lena kade ikhona ekseni. Enye imbombela.
Enye imbombela.
Hayi cha kulungile asibombeleke.
Yeah, okay. The honorable member just wanted to understand if is it still the same Mbombela which presented in the morning, and I'm saying no, it's not. Okay, so we'll get that presentation. Otherwise, there are members who were supposed to be released at 2. I think at this particular point in time, we have exhausted our work schedule. Any announcement, Valerie?
Chair, nothing from my side, but there's still a hand up. I'm not sure if you saw Mr. Unsinger earlier. Before I continue.
Or the hand of Mr. Honorable Unsinger is brown. I did not see it. I'm sorry, Honorable Member. I did not recognize your hand. You can go ahead.
Thank you, Chair. Now, I was also just wondering whether you can see my hand, Chairperson, irrespective of the color, because I don't think that should play any part. But can you just confirm that you can see my hand?
I can see it now. I did not see it at that particular time. It's clear.
There were several other occasions as well. So I'm just checking at the end, Chairperson, seeing that we will have more sessions coming forward. But as indicated earlier on, I'm looking forward to having these sessions in person at Parliament. But I'm sure you will get grip on this. Thank you, Chairperson, and I appreciate the session and the way that you have led it. Thank you very much.
Honorable Hunsinger, thank you very much. I'm sorry that I could not recognize your hand, irrespective of the color. Valerie, you said nothing on your side.
No, Chair, I will just update tomorrow's program to add a Bombela operating company for the meeting that's scheduled to start at 4 o'clock.
Thank you very much. Let's meet at 4 o'clock in the afternoon, am I right?
Yes, Chair.
The meeting is officially adjourned up until tomorrow. Long live everybody. Thank you.
Chair. I just want to register my apology already. I'm sure you have heard of the tragic incident that took place last week, Thursday, where children died tragically in an accident here in Potchefstroom. Unfortunately, one of the children belongs to a colleague and a friend. So from tomorrow, we are attending a revivalist memorial service for all the children, which starts around that time. So I will not be available for the session.
Thank you very much.
Thank you,
Thank
Chair.
you. Thank you, everybody. You are released.